All right, good morning, everybody. It is 9:03 a.m. on June 3rd, 2022, and this is a meeting of the Oil Conservation Commission. I am Adrienne Sandoval, Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Would the other two commissioners please introduce yourselves?
Hi, good morning, everyone. I'm Greg Bloom. I am the designee of the Commissioner of Public Lands.
I can't hear you.
Good morning. I'm Greg Bloom. I'm the designee of the Commissioner of Public Lands.
Thank you.
Good morning. I'm Dr. William Ampuma, professor at New Mexico Tech and also designee of Energy Secretary. Thank you.
All right. Also with us today is Florine Davidson, Clerk to the Commission, Chris Moander, Counsel to the Commission, and then Felicia Orth will be the hearing examiner for agenda item number 4 on today's agenda. All right. First item on the agenda is approval of the agenda. Is there a motion to approve the agenda?
So move.
I'm still having a hard time hearing you, Greg. You like kind of fade in and out.
Yeah. Is that better?
Yeah.
Okay. Yeah, I so move, Madam Chair.
Madam Chair, I second.
Mr. Moander, would you please do a roll call vote?
Yes, Madam Chair. Dr. Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
Motion carries.
All right. Next item on the agenda is approval of the May 12th meeting minutes. Is there a motion to adopt the minutes?
Chair, I so move.
Second.
Moander, would you do a roll call, please?
Yes, Madam Chair. Dr. Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
The motion carries.
All right. Next item on the agenda is case number 22719, application of the Oil Conservation Division to amend rules 1915.2 and 1915.7 NMAC. And with that, Ms. Orth, would you please take over?
Thank you very much, Madam Chair. My name is Felicia Orth, appointed as a hearing officer to conduct the hearing in case number 22719, the application of the Oil Conservation Division to amend rules 19.15.2 and 19.15.7 of the New Mexico Administrative Code. The hearing is being conducted under the New Mexico Oil and Gas Act and the Commission's rulemaking rules in 1915.3 of the New Mexico Administrative Code. Commissioners, the file includes, and all of this is on the Commission's webpage, the application for rulemaking from the Oil Conservation Division, a public comment from NMOGA, the notice of public hearing of the rulemaking this morning, the order of my appointment, a pre-hearing statement from the Oil Conservation Division, which is the petitioner here, and I'll note that Exhibit 1 is the proposed rule. There were other exhibits. A pre-hearing statement from NMOGA. While the OCD pre-hearing statement had noted they would be calling 2 witnesses this morning, Mr. Brankard and Mr. Powell, NMOGA did not note that they would be calling witnesses this morning. Their comments are more technical or legal. And than the slide presentation from the petitioner OCD. Again, all of that is on the webpage in the case imaging file for 22719. All testimony will be taken under oath and is subject to cross-examination. I will invite public comment a couple of times. You can offer public comment in writing until noon today, as I understand, or when I invite it during the hearing. So let's begin with the introduction of counsel here. Mr. Tremaine?
Good morning, Madam Hearing Examiner, Commissioners. My name is Jesse Tremaine on behalf of the Oil Conservation Division.
Good morning. Mr. Felderworth?
Good morning, Mr. Orth. It's good to see you and Madam Chair, members of the Commission. I'm here on behalf of the New Mexico Oil and Gas Association, otherwise known as NMOGA.
Thank you very much. And shall we begin with, do you have an opening statement, Mr. Tremaine?
I have very brief opening remarks, Ms. Orth.
Please go ahead.
Sorry,
good
before
morning.
you get going, Mr. Tremaine, Mr. Worth, should we just make sure nobody wants to do public comment? I think we had said we would do it up front.
Okay. I hadn't caught that we would do it up front. If you are on the platform and you would like to offer public comment on this petition in 22719, please reach out through the chat. We'll pause a moment to take that comment if you reach out through chat.
Also, it appears that Mr. Bloom got kicked off, so we might want to wait for him for a moment.
And we definitely did lose him. I just got a text message. So, but yes, we should pause until we can reacquire our missing commissioner. He's working on getting back in. Commissioner Bloom's going to reboot his computer and then try again. He's not able to get in. So stand by for that.
Okay, thank you. All right, it's 9:17 and we're going to resume. Sorry, Miss Orth, I think let's go back to you. There's only, I think, potentially one person online right now who may or may not have a comment. So go ahead, Miss Orth.
And I don't know that I can see the chat. Would you tell me the name, please?
Nobody has chatted yet. There is just one person online who is not associated with the hearing directly. Mr. Hall. So Mr. Hall, if you have a public comment, you can send me a chat directly and we can provide an opportunity for you to make a comment.
All right. We can wait a moment, Madam Chair, in the event Mr. Hall sends you a message.
Nothing, Ms. Orth.
All right. There will be several other opportunities to offer public comment in the event anyone is on the platform currently or joins us before we adjourn. Commissioner Bloom, you missed nothing. Mr. Felderword introduced himself, and then we started looking for public comment and didn't have any. So let's go then to Mr. Tremaine's opening remarks. Mr. Tremaine.
Thank you, Madam Hearing Examiner. Good morning, Madam Chair, Commissioners, Hearing Examiner Orth. The Oil Conservation Division filed this application to amend Rules 1915.2 and 19.15.7 NMAC for specific limited purposes. The purposes are to update the rules to clearly and accurately reflect the current operational structure of the Oil Conservation Division. For instance, removal of references to specific districts or district offices that exist in the current rule. To also modernize the official operation of the Oil Conservation Division. specifically to permit the electronic submission of documents by operators through the OCD permitting system, rather than relying on references to paper and hard copy submissions. Another purpose is to consolidate and to clarify certain sections of the existing rules, which Mr. Brankard will testify to shortly. And also, I just want to point out that the Oil Conservation Division's proposals, these edits do not propose any amendments that make substantive changes to the Oil Conservation Division's practice. These are administrative and procedural changes to reflect how agencies operate in 2022 and to kind of standardize and clarify existing language in the rules. The Oil Conservation Division will present two witnesses today, Mr. Brankard and Mr. Powell. Depending on how the commission wants to proceed, I am prepared to offer these witnesses in sequence or as a panel. It is entirely up to you. I can proceed with direct in sequence and make them available for questions as a panel. I leave that decision to you. I want to point out briefly that the division presents 10 total exhibits. We will address exhibits 1 through 5 during direct testimony and move their admission. Exhibits 6 through 10 are notice documents that are not prepared by the division, but those are provided merely to assist the commission in verifying those notice requirements. So we can discuss those in detail later on as the commission wishes. And I can describe the nature of each of those, but those are for the commission's to assist the commission. And that is my opening statement. Thank you.
Thank you, Mr. Tremaine. Mr. Feldewart, do you have any opening remarks?
Yes, Ms. Orth, if I may, I can explain a little bit why we're here and what we filed before we get started. Is there a way I could share my screen?
I can give you screen share. I'm having a little bit of trouble hearing you, Mr. Feldewart. I don't know if I'm the only one.
Is this better?
Yeah.
better?
Yeah.
Okay, I'll make sure I lean in. So I want to try to bring up what we filed as NMOGA Exhibit 1. Which I'm hoping you now have on your screen. You see that, Madam Chair?
Yes.
Okay, great. So what I tried to communicate with NMOGA Exhibit 1 is that we took the division exhibit and I highlighted in yellow our proposed changes, and they should show up in blue. So the red line strikeouts you see on here are all the divisions changes, which NMOGA has no concerns about. Our concerns relate solely to section 1915.7.9, which is titled Forms Required on Federal Land and Minerals.
Mr. Felderberg, excuse me, Madam Chair, Madam Hearing Officer, if you could, Mr. Felderberg, zoom in a little bit just to increase the font size there, that'd be helpful. It's coming
I
across
certainly
a little
will.
small.
Thank you. So we have this general provision. Is that better, Mr. Bloom? Super.
Perfect, thank you.
It's forms required on federal land or minerals, and there's two aspects about this rule that I want, this change that I would want to focus on. So this is as I understand, an update of the rules, and it really updates the relationship between the federal and tribal governments and the division. Subsection D, as in David, under 1915.7.9, deals with lands or minerals owned by a Native American nation, tribe, pueblo, or individual allottee. And it correctly recognizes that the division does not have authority over those lands, but they do require that the forms be filed with the division so they can keep track, as I understand it, of things going on. I totally understand that. And they note at the bottom, at the last sentence, that such forms involving exclusively lands or minerals that a Native American nation, tribe, pueblo, or individual allottee owns are not subject to division review or approval unless such review or approval is authorized by a written agreement between the Native American nation, tribe, pueblo, and division. And that is correct as a matter of law, as a matter of sovereignty. The division does not have jurisdiction over these lands, but I certainly understand why they would want filings to occur with them to keep track of what is occurring. Now, when I get to subsection C, this subsection deals with lands or minerals owned exclusively by the federal government. And as a matter of law, I don't think there's any debate that the state agency, the division, likewise does not have authority over federal lands or minerals. And so in updating these rules, it seemed to me that the same type of structure that you see over here in subpart D for tribal lands similarly applies to federal lands. The BLM has jurisdiction. So what I did was I took the last sentence that we see in subsection D that I read to you, but there being the necessity of an agreement before those forms can be approved by the division, and added that to the provision dealing with federal lands and minerals. And then I simply removed the first sentence in the for approval language in there to reflect the legal position that the state, absent an agreement with the BLM, does not have the authority to approve activities on purely federal lands and minerals. I don't think there's any debate about that. So that was the purpose of our change. That's why I'm here, and I appreciate your consideration of this of these changes.
Thank you, Mr. Feldewart. Back to Mr. Tremaine. Mr. Tremaine, my preference would be that you call your witnesses in sequence and that they then be questioned as a panel. That would be my preference.
Thank you, Madam Hearing Examiner. The Oil Conservation Division would call William Brankert.
Mr. Brankert, if you would please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Tremaine.
Ms. Orth, do you have any concerns with my sharing screen to share the OCD's exhibit binder?
Nope, no concerns at all. And Madam Chair has that button in her control.
You should be able to do that now.
Thank you. Mr. Brankert, could you please state your name for the record?
My name is William Brancard.
And on whose behalf are you testifying today?
On behalf of the New Mexico Oil Conservation Division.
I'm going to share screen. Mr. Brankert, can you now see my screen?
Yes, I can.
So I'm going to direct you to what is labeled as OCD Exhibit 1 -001. Is this your curriculum vitae?
Yes, it is.
And did you prepare this CV prior to this hearing?
Yes, I did.
And does this curriculum vitae accurately represent your relevant education and experience related to today's hearing?
I hope so.
Okay. Madam Hearing Examiner, I would move admission of Exhibit 1 as Mr. Brankert's curriculum vitae.
All right, unless I hear an objection, Exhibit 1 is admitted. And might I add, Mr. Brankert, you're very quiet.
Okay.
And excuse me, Madam Hearing Officer, if Mr. Tremaine, if you could zoom in a little bit on your screen shares, that'd be helpful as well. That's perfect. Thank you.
Absolutely. Thank you. So, Mr. Brankard, could you please provide a summary of your education and experience for the commission?
Certainly. I have a law degree, bachelor's degree, and I have been working for the state of New Mexico since 1991 at various agencies, including the New Mexico State Land Office and the New Mexico Attorney General's Office. I have been with the New Mexico Energy, Minerals, and Natural Resources Department since 2003. And I worked as a division director, as general counsel, and now I am hearings bureau chief.
And so your current position with NMED is as the Oil Conservation Division's hearings bureau chief?
Yes, with MNERD, that is. I'm the chief of the hearings bureau.
Thank you. And could you please briefly describe your role as your history as MNERD's general counsel?
Yes, as general counsel, I oversaw the actions of the attorneys working for the department who provided advice to all the divisions of the department: forestry, parks, energy conservation, mining and minerals, and OCD. One of my tasks during that time frame was also I was counsel to the Oil Conservation Commission.
Thank you, Mr. Brankard. I would like to direct your attention now to OCD, what is marked as OCD Exhibit 3 dash 001 and sequence. Is this the Oil Conservation Division's proposed amendments to Rule 19.15.2?
Yes,
And did you assist in preparation of this document?
I was one of a number of employees of the OCD who worked on this draft, coming up with the version you see before you.
I would like to also now draw your attention to Oil Conservation Division Exhibit 4. And likewise, does this reflect the Oil Conservation Division's proposed amendments to 19.15.7?
Yes, it does.
And did you also assist in preparation of this document?
Yes, again, as part of a larger team of people working on this.
And last, before we get into the specifics, I'd like to draw your attention to OCD Exhibit 5. Mr. Brankard, what is this exhibit?
This is the PowerPoint presentation that sort of summarized the testimony that myself and Mr. Powell will be providing.
And did you assist in preparation of this document?
I did. Mr. Powell put a lot of work into it and I assisted.
Okay. Madam Hearing Examiner, at this time, I would move for admission of exhibits 3, actually 3 through 10. But if you'd like, I can provide some additional foundation for items 6 through 10.
If I remember your opening remarks, 6 through 10 related to the notice, public notice of this hearing. But let me pause for a moment in the event there are objections to exhibits 3 through 10.
So this is Mike
objections?
Feldoward.
Yes.
This is Mike Feldoward. We have no objection to any of the division's exhibits, so we can move forward.
All right. So I think then we can admit exhibits 2 through 10. If I remember 2, it was Mr. Powell's resume. So exhibits 2 through 10 are admitted. Thank you.
Thank you. All right, Mr. Brankard, could you please just give a summary of your testimony related to the proposed amendments today?
Yes, I'll try to give a little background on this. I guess first, sort of apologize to the commission that this is not a very exciting rulemaking proposal. We're basically dealing here today with processes that the division uses to implement the Oil and Gas Act. These kinds of rule changes are often low priority, so they often get put off. And so in reality here, unlike recent rulemakings where the commission considered new programs or ideas, in this case, we are having to change the rules to catch up with reality. Let me give a little bit of background here. The commission was created 87 years ago, and one of its first actions was to adopt a set of regulations to implement the new Oil and Gas Act. So the commission has been in the business of adopting rules for a very long time. And those rules have been added to and amended over the years. Those were basically done as orders issued by the commission. It wasn't until after 60 some odd years that these rules were ever compiled into what you see now under the New Mexico Administrative Code. And also for 50 years, the commission was the agency. There was no Energy, Minerals, Natural Resources Department. There was no OCD. The commission oversaw the entire implementation of the act. And so that's why some of the commission's rules did and still do have sort of administrative procedures in them, which we'll touch on at points today. And whether it's appropriate for those to actually be rules of the commission is the question that we are throwing out. So the model that the commission had for many years in implementing the Oil and Gas Act was requiring parties, generally operators of oil and gas facilities, to provide information and documentation to and applications to the agency on forms. These are written forms that you got from the division, you fill them out and you walk them over to the local OCD or commission district office and submitted them. And that process is still largely reflected in the commission's rules. What has happened, though, in the last few years is that the division has been working on transitioning over to electronic submittal of forms and information. First a little bit, first as sort of an option for certain operators, and then more full on. And with the pandemic, that whole process got accelerated. And thankfully, with the pandemic, this process was already implemented because it made life a lot easier for both the agency and the operators to be able to use electronic filing when division offices were closed. But that electronic filing is not at all reflected in the commission's rules. And so what we are trying to do today is to update the commission's rules to reflect the current reality. We probably maybe should have brought the entire set of commission rules in to be amended and go through section by section every reference to how you file a document and changed it. But we decided to do a simpler process today and look at just two parts of the commission rules. Part 2, which is general provisions, and Part 7, which is forms. It's an entire part just on forms. And tried to put in general provisions there that allow for electronic filing and override other requirements in the rules about having to walk into a district office with a piece of paper. So those are largely what we focused on. In looking at rules 2 and 7, we saw other areas that needed updating in doing that, and those will be discussed today by myself and Mr. Powell, dealing, say, with the concept of district offices that the commission, when it was running the agency, designated exactly where every district office should be located. And also, as Mr. Feldewart mentioned, we did try to update the provisions related to the filings of forms for federal land and for tribal lands. For federal land, we really made no changes in the process. For tribal lands, we tried to update it based on the reality, as Mr. Felderwerd noted, of the tribes being separate sovereigns. So that's a little summary. Hope I didn't go on too long, Mr. Tremaine.
Thank you. Mr. Brinker, I'm going to share screen again and ask you to please describe, if I can actually execute the share. All right, can you see my screen now?
You can, Mr. Tremaine, but there's a gray square squarely in the middle of it. There we go. Thank you.
All right. Mr. Brinker, could you please describe the statutory authority under which OCD proposes the amendments reflected in Exhibits 3 and 4? And I'll draw the Commission's attention to OCD Exhibit 5-003.
Yes, the Commission and the Division are given rather broad authority under the Oil and Gas Act to do what actions are necessary to implement the goals of the Act. More specifically, if you look at Section 70-2-12, which is a grant, not only a specific grant of authority, but also authority to adopt rules, there are specific references to collecting data, making investigations and inspections, examining books and records, provide for the keeping of records, etc. And then there are specific rules that we will touch a little bit today with many of these forms that relate to reports on locations of wells and ownership, etc. So all these rules that we're talking about today that deal with filing of forms and reports, they're basically the implementation of the Commission's and the Division's responsibility under the Act to regulate various activities of the oil and gas industry.
Okay, if I could now draw your attention to OCD Exhibit 5-004. Mr. Brinker, could you please describe the stakeholder engagement which OCD engaged in related to this rulemaking?
Yes, after an extensive internal review process that went on for a long time, because a lot of these changes that we're discussing affect various people in the agency, and we really wanted to make sure we were actually reflecting what the reality was on the ground in these rules. We began an external process of getting engagement from other entities. Because we were dealing specifically with the rules regarding oil and gas development on tribal lands, it was necessary to engage in tribal consultation, which we did in October of 2021 by mailing a draft of these rules out to all New Mexico pueblos, tribes, nations, and requesting input and discussion. We did get some feedback from the tribes, including support for the OCD continuing to serve as sort of a repository of information on oil and gas for the entire state. So that was interesting, and we actually updated the rules to reflect the tribe's interest in that. We also then, soon after, submitted this to agencies that we deal with more directly, such as the State Land Office and the Bureau of Land Management, and asked for feedback. I will say we really didn't get any feedback at all from those agencies. Then we decided to do an informal public comment period prior to bringing this rule to the Commission. We have done versions of that for very detailed rules, such as the waste rule proposal that this Commission dealt with the last year or two. But it hasn't necessarily been something we've done with every rule. And I think this may serve as a model for us to do kind of an informal public comment period prior to going to the commission. In this case, we have a whole mailing list that we have for all rule hearings and division proceedings. And so a copy of the draft rule was sent out to that entire mailing list. And we had a period of about 3 to 4 weeks allowing for comments from parties. The only real comments we received were from the New Mexico Oil and Gas Association. So again, as we said, we got comments from various parties. We incorporated certain changes based on those comments, and then we filed the proposed rule changes with the commission on March 30th.
Okay, Mr. Brankert, I'd like to draw your attention to OCD Exhibit 5-005. Could you please describe or summarize the notices that were issued by OCD related to this rulemaking?
Yes, the commission is required to provide notice to a number of entities. These requirements are both in the State Rules Act and in the commission's rules of procedure, which actually go a little further than the Rules Act. And so we worked with the commission clerk to make sure that notice was published in the proper locations and were sent out, not just the people on the rulemaking list as indicated here, but also I believe we have to send it to the Legislative Council. It has to be posted on the State Sunshine Portal. So there's a whole number of items we have to check off, and we work with the commission clerk to make sure that that happened.
Thank you. I'm going to move forward to OCD Exhibit 5-007. Mr. Brankert, please provide an overview of the proposed changes represented in Exhibits 3 and 4 today.
All right, I'll try to be brief. Mr. Powell will have a lot more details, especially since he is sort of a person on the ground who deals with a lot of this reality and can provide you with the information about what it is we exactly do and how the rules now comport with that reality. But the main change here is to both in both parts 2 and 7 is to recognize that now the agency is requiring that documents, forms, information, etc., all be electronically filed with the agency. And so there are various sections in parts 2 and 7 that Mr. Powell will go into more detail on that provide exactly that requirement now. That instead of dropping something off at the district office, as I indicated earlier, you file electronically. And the electronic system has been up and running for some time now. You know, I think we've worked through any bugs in it. We continue to refine it constantly. And it's working quite well. So this is a good time to make this part of our rules here. What we tried to do then, again, as I said, instead of going back through every little mention of filing that's in all the commission rules, we just made a general statement that wherever filing is required, you will do it electronically according to the provisions in parts 2 and 7. So that is a big chunk of what this rulemaking is all about. As I mentioned, we went through other parts of, while we were at it, 2 and 7, to make a few changes to try to deal with current reality, such as the reality of district offices, etc. And then we also, the language in part 7 relating to federal and tribal governments, it was 2 separate sections far apart from each other. We merged them into one and tried to make that document work better and also reflect how we currently deal with these filings on both federal and tribal land.
Thank you. Ms. Orth and commissioners, I'm going to ask Mr. Brankert a series of questions about part of certain future slides, but the bulk of the remaining slides will be testified to in more detail by Mr. Powell. So with that, I'd like to move on and Mr. Branker to direct your attention to OCD Exhibit 5-009. This slide references the Oil and Gas Act, and I'm hoping that you can describe the amendments referenced on page slide 9 as they relate specifically to the Oil and Gas Act.
Yes, we added 3 new definitions. 2 were sort of remarkable that they were never put in the definition sections, maybe because they seem obvious to people, but you know, there are references constantly through the commission's rules to the Oil and Gas Act and to the rules themselves. And so we just wanted to try to come up with a more consistent use of how one refers to both the Oil and Gas Act and the commission's rules, and created definitions therefore for the act and the rules. The third definition comes out of issues, and Mr. Felderwerd is quite aware of these issues too, related to many of our notice requirements require that notice be provided by certified mail. And it's just becoming quite the problem with the U.S. Postal Service these days. And it's a struggle to get the mailings done timely way. And it's a struggle for both the division and the operators, the applicants, to provide proof that they provided this notice. And so with the recommendations from the EMNR legal division, we have a sort of a broader definition of certified mail here that hopefully meets the goal of having notice be provided in a manner that can be tracked while not necessarily being tied to the U.S. Postal Service.
Thank you, Mr. Brankard. I will now draw your attention to slide 5-012. I'm going to have the same question. This slide references, and I apologize for the commission for the, this is a lawyer pet peeve when there's a typo of statute to statute, so I apologize for that, but this references state statutes. And I want to ask Mr. Branker to please describe the amendments referenced on this slide as they relate to the state computation of time statute.
Yes, I think the commission has for a long time had a rule. It's been in various locations in the commission rules over the decades about how you compute time, because there's a number of requirements in the commission rules about deadlines based on time. And so the commission had sort of common sense rules about how to compute that time. In the intervening years, the legislature has enacted this document called the Uniform Statute and Rule Construction Act, which has an entire section about how you compute time. Now, and so rather than the commission trying to make up its own rule, it seemed easier to simply refer to this statute. The statute actually has almost entirely agrees with the way the commission had interpreted time to begin with, except for one item, which actually is an improvement given today's world of electronic filing, which is the commission's rule refers to a period of time for a day running to the close of the business of the day. I guess that means 5 p.m. I'm not sure. If you look at this statute in the Uniform Statute and Rule Construction Act, it says a day begins at midnight and ends at midnight. So in today's world of electronic filing, that makes a lot more sense too.
Thank you, Mr. Brankard. I'm going to move on to OCD Exhibit 5-015. And again, a similar question here. This slide references specifically the Oil and Gas Act. And so I'd like to ask you to please describe the amendments referenced on this slide as they relate to the Oil and Gas Act.
Yes, as I mentioned earlier, the commission was the administrator of the Oil and Gas Act for 50 years. And so, having the commission issue an order saying there will be districts, and they are these counties, and the offices will be in these locations, made sense back then. But now administration of the agency has passed to the Energy, Minerals, and Natural Resources Department, the Conservation District, and the division director. And so it just seems no longer that that's really who should be the one in charge of figuring out where district offices are. Plus, what we are finding with the whole electronic filing and the use, how to properly use personnel, is that the division really needs to have a better view of how to move people around. It's interesting, you might know, the director would know this, but I believe the second largest office that the division has now is no longer one of the district offices. It's an office in Albuquerque that we opened a few years ago because that seemed like a better place to position people. So it really is, something that should be in the purview of the division director in their role under the Oil and Gas Act to determine what's the best way to have offices and position people.
Okay, Mr. Brankert, I would like to now direct your attention to slide 5-017. And again, this slide references federal and tribal lands. So could you please describe the amendments proposed and reflected on this slide as they relate to tribal and federal interests?
Yes, as I mentioned earlier, the current rules of the commission, there are two sections, 1915 7.11 and 7.37, right, not right next to each other, that deal with federal lands and tribal lands and forms. That seemed a bit awkward, so we decided to merge those into one section so that all the information was in one place. For federal lands, we really did not make any substantive changes here, except perhaps that we no longer reference actual names and numbers of federal forms. That's not really our job, and the feds can change those forms any day without consulting us, and then our rules will be out of date. So we eliminated those references to specific federal forms. The tribal, we did, because the existing rules kind of deal with federal and tribal lands in a similar manner, and they're not. The tribal lands, as Mr. Felderwert noted, are, subject to the authority of a separate sovereign. And so the state has very limited jurisdiction at all over tribal land. And so we tried to reflect that in subsection D about how we're treating tribal lands. The federal lands, there is really no change. The provisions that are in there are largely the provisions taken out of the existing rules, and the process remains the same. We tried to deal a little bit with timing issues because sometimes that becomes a question and we're often waiting for a form, etc. But other than that, the basic concept that you go to the federal government first with your filing, and then you can send that federal form to us, and we will review it. That's still there. It's the same language.
Okay, Mr. Brankert, have you had the opportunity to review the pre-hearing statement that was submitted by NMOGA?
Yes, I have.
And are you aware of the proposed changes referenced by Mr. Felderwert in his opening statement and reflected in that pre-hearing statement regarding federal lands and or minerals?
Yes.
Can you, zooming out for a second, can you please describe the nature of any OCD authority as it relates to federal lands or minerals?
Well, the state has authority to deal with federal lands in dealing with environmental natural resource regulation. Well, there is simply really no question that that authority is concurrent with whatever authority the federal government agencies may also exercise in that regard. But that is longstanding law. And we do it not just for OCD, we do it perhaps even more so in mining, et cetera, in this department. So that's simply the way it always has been and has been supported by numerous New Mexico and U.S. Supreme Court decisions.
In your opinion, are NMOGA's proposed edits as they relate to the federal lands or minerals issue necessary or appropriate for this rulemaking?
Well, the main change that NMOGA is proposing is to delete a sentence in subsection C of 7.9 that says that forms filed with the BLM involving federal lands or minerals are subject to division approval. That sentence is taken directly from the current regulation. So that sentence is not a new requirement. That is the existing requirement. So eliminating that requirement would be a huge policy change on behalf of the state to give up what it has always done in regard to federal forms. Mr. Powell, deals directly with the BLM on many issues, and he can give you a lot more detail about how that process works. And so he may be very useful in sort of diving into the nuts and bolts of how that works.
Thank you, Mr. Brankert. I have no further questions.
If you would present Mr. Powell then.
Thank you. The Oil Conservation Division would call Brandon Powell.
Good morning.
Good morning, Mr. Powell. Could you please state your name for the record?
Brandon Powell.
And I need to swear him in, Mr. Tremaine. Mr. Powell, if you would raise your right hand. Do you swear or affirm to tell the truth? Thank you.
Okay, Mr. Powell, on whose behalf are you testifying today?
The Oil Conservation Division.
Okay. And I believe you would have heard this, but your resume or CV has already been admitted as evidence, so I may refer you to Exhibit 2. But could you please provide for the Commission a summary of your experience with the Oil Conservation Division?
So I've been with the Oil Conservation Division for roughly 16 years. I started in 2006 as an environmental specialist. I then was promoted to an inspection and compliance supervisor, overseeing field inspection and reviewing paperwork for field operations. I then was promoted again to district supervisor, where I managed one of the district offices for the OCD in the northwest part of the state, overseeing all of the field operations that occurred in all of the district operations. After that, I was then promoted to the Environmental Bureau or Engineering Bureau Chief, I apologize, in 2020, and that's where the position I currently hold.
So could you please describe in a little bit more detail your current duties as the Bureau Chief?
Yes, so my current duties as the Bureau Chief, I oversee the administrative permitting section of the Engineering Bureau that oversees permitting for all the oil field operations, downhole operations that relate to the well. I oversee the underground injection control part of the Engineering Bureau that oversees all injection wells, their operations, permitting on that side of it. And then I also oversee the inspection program for the north and south part of the states, which oversee all of the inspectors and the inspection supervisors and implementing the inspection processes.
And in your, in your current role, and actually overall, are you familiar with the Oil Conservation Division's treatment to federal forms in relationship with the Bureau of Land Management?
Yes, I am. I've processed several federal forms. That was part of my day-to-day duties pretty much throughout my career with the OCD.
Okay. Before we get into the specifics, I'd ask you to provide for the commission a brief summary of your testimony related to the proposed changes today.
So my testimony for the proposed changes today, I'll be going through the exhibits that we have. I'll give a brief overview of what rule change, our specific rule change we'll be going over, then what those changes are and the overall objectives of that rule change.
Thank you. I'd like to direct your attention to OCD Exhibit 5-009, and I'll start screen share again. Mr. Powell, can you see my screen?
Yes, I can.
Okay, so specifically related to this slide 5009, can you please describe the amendment that is identified on the slide?
Sure, certainly. It's an amendment to 1915-27 definitions. The division is requesting to add 3 definitions to ensure consistent understanding of their use. Overall, it ensures proper understanding of the references to the Oil and Gas Act and applicable NMSA references. It provides a detailed explanation of requirements for certified mail, and then it details references of the rules contained in 1915-2 through 39 NMAC. These rules in which 1915-2 NMAC are applicable.
Okay. Direct your attention to Exhibit 5-010. Mr. Powell, could you please describe the amendment that is referenced on this slide?
Certainly. It goes over the amendment to 1915-210 online application and submittals. This is a new section detailing the process for online applications and submittals. It establishes a rule for online applications, recognizes the fee requirements for applicable forms, and details processes for the extension allowances if there's a technical failure on the OCD's online application process.
Is it fair to say that this rule change references OCD's movement to use the e-permitting system and electronic filing?
It does. It recognizes that ability that the division now currently has.
Is it fair to say that OCD is attempting to move away from hard copy submissions of various forms from operators?
It is. We're working and have worked to move totally online for those submittal applications. It allows for more efficient processing, both by the OCD, but also by the operators. Our new system allows for immediate submittals to the OCD, so you're not waiting for the mail to come in each day, hoping to see what's there. You're also getting the ability, the operators get the ability where they can track their application to see if it has been submitted and see if it has been approved yet.
Does electronic submission increase the efficiency or tracking capability for OCD internally?
Yes, it does. We can see all the applications of a specific type now. We can review them, see what's outstanding to be reviewed, and see what we've processed in the past.
Okay. I'll move on to OCD Exhibit 5-011. Same question, Mr. Powell, could you please describe the amendment that's reflected on this slide?
Certainly. It's for 1915-212, filing and notification. This is a repeal and replacement of the existing rule. The new rule provides processes on how operators should submit filings or notifications. It establishes submittals can be filed online through the OCD's website. Notifications can be made by email or pursuant to contact instructions provided by the OCD. However, it does provide that financial assurance is still required to be provided pursuant to 1915-8 NMAC.
And could you please just clarify for the commission that distinction that's made regarding the financial assurance component?
Financial assurance is one of the few items that we actually still have to receive hard copy. So we have to receive the hard copy bonding for any bonding that's required.
And I have the same question for you related to slide 5-012. Please describe the amendment that's reflected on this slide.
As Mr. Brinkert talked previously, it's for 1915-213 computation of time. This provides how the computation of time is established and ensures consistency with proper state statutes in that computation of time. It ensures there's no conflicts in the future.
And does that change substantively in any way the way that OCD operates?
No.
All right, moving on to slide 5-013. And again, please describe for the commission the amendments that are reflected on this slide.
So this one is 1915-216 duties and authority of division personnel. This change updates the rule to be consistent with the current organizational structure of the OCD and ensures the OCD gets the proper documentation of any changes. It allows proper OCD personnel to make minor deviations to approvals for field operations due to changing circumstances encountered in the field to avoid waste and protection of public health and the environment. The rule then requires any changes to be submitted to the OCD on proper forms, historizing that change.
And does this proposed amendment in part 2.16, does that propose any substantive changes for OCD staff or such as a change of duties or anything else?
No, it's more to recognize the current organizational structure of the OCD, where we previously had district offices, and those offices would house things like geologists that would make calls for plugins that are going on in the field. Those geologists are now housed under the Engineering Bureau. So if changes are made, they're not made from quote unquote a field office or a field personnel any longer. They're made by Engineering Bureau personnel. So it's just recognizing the current organizational structure.
Are you able to actually describe for the commission just very briefly what that restructure looks like?
Sure. So it's a more centralized structure and makes it more cohesive in the state. So instead of having individual district offices in the different parts of the state, because of the online applications and the improvements in processing as far as being able to review things statewide, the district offices are not silos in information any longer. What it is all of those applications get submitted to the OCD in general. The OCD district offices were split up more into the engineering, environmental, and administrative bureaus, where those processes are more of a statewide process and handled on statewide structures. So, for example, APDs, instead of going to the individual district offices, those go to the Engineering Bureau for review.
Thank you. I think you covered this, but I just want to be clear. So the prior version of the rule, is it accurate to say that that the rules historically referenced field personnel?
It did.
Okay, and the new version of the rule is intended to reference bureau personnel?
That is correct. Because of the organizational structure, there may be people that are in, say, the Engineering Bureau or the Environmental Bureau that wouldn't, quote unquote, be classified as field personnel because they're not in a field office any longer. But they are still the same responsible people for making those decisions.
Okay, so they're the same responsible people and they're doing the same work, is that correct?
That is correct.
Okay. Then I would like to move on and refer you to OCD Exhibit 5-014. And repeated question, please describe for the commission the amendments that are reflected on this slide.
Certainly, this is very similar to the information given in the past slide. It's for 1915-217 organizational units. This changes the updates in the rule to be consistent with the current organizational structure of the OCD. The OCD no longer operates in individual district units due to the online process. This is now more of a cohesive organizational process. The rule does recognize the OCD may need to develop particular units as appropriate when the need arises, and will provide a map of such units.
Are the changes here likewise administrative in nature?
They are.
Then I would refer you to OCD Exhibit 5-015. Please describe the amendment that's reflected on this slide.
This one's to 1915-7-8. The general statement, it applies to how operators should submit forms. The changes also update processes to be consistent with the statutes. It updates the rule to allow for the creation and implementation of online submittals, provides the OCD will maintain the submittal processes for forms and applications on the OCD's website, and other updates for consistency with the current Oil and Gas Act.
The submission of forms, does this change, alter in any way the substance of the forms that are submitted by operators?
No, it doesn't. It just the manner in which they're submitted.
I will move on to slide 5-016. Mr. Powell, could you please describe for the commission the amendments reflected on this slide?
It's a repeal of the current 1915 7.9 and 10. These rules are current versions of the rules strictly apply to hard copy forms and submittals that are no longer used.
So with this rule change, OCD is moving to strictly e-permitting submissions and no more hard copies, correct?
That's correct.
Thank you. Then I will move on to 5-017. Mr. Powell, please describe the amendments that are reflected on this slide.
Mr. Brankard also went over this to an extent. It's for 1915 7.9 forms required on federal lands or minerals. It combines and repeals 1915 7.11 and 37. And this new section, it will combine and modernize the current parts of 11 and 37 regarding applications on federal lands or minerals. The rule recognizes the form types filed on federal and tribal lands. It removes the sections where the BLM would forward the forms to the OCD, as they've also changed their process to an online submittal process. It recognizes tribal rights and sovereignty, and it provides a mechanism for the OCD to get critical information if there's a delay in federal processing.
And a couple of follow-up questions on this one. Is it accurate to say that one of the primary functions of this proposed amendment is to consolidate those references in the separate sections of rule?
Yes, it consolidates both 11 and 37. They're very similar in their overall statements of filing federal forms to the OCD, and it combines those.
Did I understand your previous statement to be that the Bureau of Land Management, at least to the extent of your understanding, relies or focuses on electronic filing at this point?
Yes, that's my understanding.
And I want to ask you specifically about the change of forms referenced here. Is this in reference to, we heard testimony earlier about a delay in federal forms. And so I'd ask you to kind of provide a little more detail in how these amendments relate to OCD's receipt and review of federal forms or information when there is that delay in a federal form. Sorry, did that question make sense to you?
I think so. So what it is the OCD, there's forms that we get critical information off of for subsequent reports via casing, completion reports, those kind of forms. So because of BLM processing or their workload, there's times where there's delays in us getting their forms. So this rule provides an avenue to the operator to get that critical information to us in a timely manner, so we can get that in and put it into our system and make sure there's no conflicts in what we're seeing. So it provides that avenue to get that information to us.
Could you please provide for the commission an understanding of how operator assets may be identified as federal within OCD's system?
So the way the OCD system works, we have overriding assignments for minerals. So anytime there's any federal minerals assigned to the well, that well in the OCD system gets classified as a federal well, even though all minerals may not be federal. Similar to if it has state minerals, but no federal, but it may have private, it gets classified as a state well. So it has overriding functions to be shown in the OCD system.
So the assets or wells in particular that are referenced within OCD system as federal, those are not limited to those wells or assets that are quote unquote exclusively federal. Is that correct?
That is correct. They could be exclusively, or they could be, for example, 1% federal, and they would still be classified as federal.
Now, could you please provide for the commission kind of summarize from your experience working with OCD, OCD's history of approving and or conditioning activities which affect federal lands or minerals?
So my experience is consistent with the rule that's currently in place, that all forms referenced in those rules are subject to same review and approval by the division. So once we receive the federally approved sundry, we review it to ensure state rules and state obligations are met by the operator. If they're not, we'll add conditions of approval. My understanding historically is if there is a conflict in the conditions that we add with the BLM, it would have to be a direct conflict. If that's the case, then we contact the BLM and work with them to resolve that conflict before adding that condition. But we regularly add conditions of approval to federal forms to ensure that whatever operations are being submitted comply with state rules and regulations.
So am I understanding your testimony correctly to be that OCD's receipt, review, and approval of federal forms is to the extent of OCD's enforcement or oversight related to the Oil and Gas Act and OCD rule?
That is correct.
Okay. Now I would like to move on to refer you to Exhibit 5-018. And I want to ask you briefly to describe the amendments that are reflected in this slide.
So this slide shows the amendments 1915-716 well completion or recompletion report and log form C-105. Its update to the rule to recognize current processes. It updates the rule to be consistent with the current organizational structure of the OCD, and it updates the application of the injection well types that don't require a C-104.
And is there a typo in that second objective there?
There is. In the second objective, the words "the on" should be struck.
Okay. Could you just please clarify for the commission what's meant by that, particularly that second objective there?
Certainly. So the C-105 is the completion report. It gives us pertinent data and substantial data for our review. It ensures that completions are inside formation because it provides formation tops, perforation depths, all of the additional casing information. The intent of that section historically has been, if we don't get that critical information, is to suspend operations until we do, to make sure they're in compliance. Previously, it referenced the C-104 process. Because the C-104 process isn't applicable to injection wells, it was just a gap in information. So we added the injection well types to be suspended to allow us to get that critical information before continuing to make sure all of the critical information is reviewed.
Does this proposed amendment change in any way reflect a change in policy for the Oil Conservation Division?
No, it doesn't. The intent of that provision was always to allow the operations to stop until we got that critical information. It just ensures that it applies appropriately.
Thank you, Mr. Powell. Madam Hearing Examiner, I have no more questions for Mr. Powell.
Thank you very much, Mr. Tremaine. Mr. Feldewart, do you have questions of the division panel based on their testimony, either of Mr. Powell or Mr. Brankard?
I do have a few questions, but I'm wondering if, since it's 10:30, if we can take a quick break, just so I can step down the hall, to be honest with you.
Yes, of course. The well-known bio break. Let's come back at 10:40. That's
Thank you.
14 minutes. Thank you.
Anytime I see someone talking and I can't hear them, I assume it's on my end. I'm like all panicking, checking all my audio functions. It's kind of funny. After 2 years, I still do it. Like, clearly it must be on my end.
Can you see me, Mr. Boander?
I can, but I saw you start to talk and I think you were still muted. And so I'm like scurrying around my own desktop.
Oh, there might be a, I don't know, a heartbeat of a delay or something on the audio. All right, thank you though. Let's see, Mr. Feldewart, and do we have Mr. Powell and Mr. Brankard back with us?
As well as Mr. Tremaine, right?
Yes. I see Mr. Powell. I see Mr. Tremaine, and
I'm here.
I see Mr. Brankard. All right. Mr. Feldewart, if you would please, your questions for the division panel.
Yes, thank you. First off, I'll say I struggle in that I don't know if I miss the old days or not, because I kind of like the days when we used to deal with paper and you had something tangible. And I still print stuff out. I saw, Ms. Orth, you actually printed stuff out too. And having the personal contact between the agency and the industry, those day-to-day filings, that personal contact. But, I know we had to move to the next generation. I know the division invested substantially in all this electronic filing. So, here we go into the next generation, I guess. I want to thank the division, Mr. Brankard, for especially to the extent you had an input there on changing certified mailings, because as you pointed out, that has become very difficult with the United States Postal Service. And I'm looking forward to that change passing so that we can perhaps use other courier services that provide better updates on what has actually been, sent and received by certified mail, particularly for pooling cases. On the computation of time, Mr. Brankard, I am going to ask for some free legal advice. You were kind enough to point out that the new statute primarily tracks the old computation of time rule that we've been using for a long time. My question is, I'm assuming that legal holiday issue still exists under the current statute in computating those 10 days.
Yes, Mr. Feldewart, it follows the same rule, which is anything less than 11 days
Yeah.
is subject to Saturday, Sunday, or public holidays.
Okay. All right. Thank you. If I could have sharing capability.
Yep, let me pass that to you. You should be able to now.
Yes. Do you all see this? This is the NMOGA Exhibit 1. And I am going to increase it there. Thank you. So I want to talk a little bit about these, what we proposed here and what the division's done. I understand from the division exhibits, when I look at slide 7 of exhibit 5, that one of the provisions changes that you sought to accomplish here was to, and I'm looking at the third bullet point. Other changes seek to replace outdated rule language with provisions that reflect the current reality of OCD organization and the relationship with federal and tribal governments. Now, we talked about those changes in 1915 7.9, which was on your slide 17. Are there any other changes that really fall into that bucket of recognizing the relationship with federal and tribal governments?
I guess I'll jump in. I think it was just 7.9, which is a combination of the old 7.11 and 7.37.
Okay, all right. So then if I go to the old 1915 7.11, I think that's what you were referencing, Mr. Brankard?
That's correct.
Okay. Now, so starting to where things were, it said for wells located on land that the United States or a Native American nation, tribe, or pueblo owns, an operator shall file. And then it goes on to describe that. And then it had the last sentence. All such forms are, however, subject to division approval in the same manner and to the same extent as the corresponding division forms. Now, am I correct that under this, I guess it's still an existing rule, division approval was required for forms that were filed on purely federal lands or purely American nation, tribe, or pueblo-owned lands? Applied to both, right?
The explicit language of the rule applies to both. In reality, that had not been the situation for some time, that the state was not exercising jurisdiction over tribal lands. Mr. Powell may have some history on that he can elucidate.
All right, so we start with that. And then one of the things that the division did was to, as we pointed out, address the circumstance with American nation, tribe, and pueblo lands by taking out that approval requirement. Is that right?
Yes.
Okay. But the similar change was not done for federal lands.
Correct.
Even for what I've heard you term or others term exclusively federal lands and minerals. So not where we have a mixture of lands, but the division is still taking the position that it approves forms and activities on purely federal lands and minerals.
Yes.
Okay. Now, there's no statute that grants that authority, right, Mr. Brankard?
Yeah, the U.S. Constitution.
Okay. And you're talking about, when you say that, are you talking about concurrent jurisdiction?
Yes, I think that's one way it's referred to. Yeah.
I think that's what you referenced during your testimony. Is that right?
I may have.
Okay. At one time, Mr. Brankard, wasn't there an agreement between the division and the Bureau of Land Management that's specifically authorized the division to exercise jurisdiction over federal lands?
I'm not aware of such agreements. In my time here, there have been attempts to negotiate a memorandum of understanding or agreement with the BLM to sort of work out the details of the processes, but I'm not aware of any agreement. And certainly we wouldn't have been granted that authority because we already have that authority.
You're not aware that there used to be a memorandum of understanding back in the
I'm not-
90s?
Well, that's before I was at the department, yes.
Were you apprised that there used to be a memorandum of understanding between the two agencies?
No.
Mr. Powell, are you aware of that?
I'm generally aware that there was a memorandum. I haven't seen it. My understanding of the memorandum and then subsequent actions to get that memorandum of understanding after wasn't granting the state authority over federal lands. It was a memorandum on how certain actions would be dealt with between the BLM and the state as far as reviews and those kind of things, and to make sure there wasn't a duplication of efforts to help streamline some of it. But my understanding of the memorandums wasn't to grant authority, it was to work through processes between the two agencies.
So if I read subparagraph C now, am I correct that you, for purely federal lands, and that's just what I'm focused on here, purely federal lands, because our last sentence just deals with exclusively federal lands, okay? If our operators have an activity on purely federal lands or purely federal minerals, they are to file their forms with the Bureau of Land Management, correct?
Correct. They would file it with the Bureau of Land Management first.
Okay, so that may be an application to drill, which would be the equivalent, I guess, of your C-101.
Correct.
Might be a sundry notice, which would be the equivalent of your C-103.
Correct.
And then they wait for the division to approve that. I'm sorry, the BLM to approve that.
That is correct.
Then they have, and you referenced the fact that in some activities, there are some delays in getting the approval from the BLM and thereby allowing you to act.
The delays that I previously referenced was on the subsequent reports to get information after an action had taken place.
Are you aware of delays in getting approvals from the BLM for applications to drill or other sundry notices?
I've heard there's delays because of the different regulations that BLM enforces versus the OCD. APDs are a great example. Sometimes I've heard it can take years for federal approval. However, once the federal approval is received and that APD is submitted to the OCD processes them typically under 10 business days.
Currently.
And
we don't know what's going to happen in the future, right? Okay. And then once they get the BLM approval, before they can act, now, according to the way this is written on purely federal lands, they now have to file it with the division. And I know you all said review, but don't they have to file it with the division and wait for approval before they can act?
That would be correct, that it's still processed the same as every other state form.
Did the division have any discussion with the BLM about this concept that the division is required to approve activities on purely federal lands?
So I've had discussions with the BLM historically. Bill can talk about this rulemaking specifically because I believe that notice came from him. But I've worked in the northwest part of the state for my career, or the majority of my career, and federal lands make up, and I'm going to say roughly 70% of the northwest. So I've had normal interactions with the federal government, with the BLM, and we have discussed, state COAs, state approval processes for a majority of my career. The rights of the state on federal lands has never been in question. Sometimes the means in which we add those conditions were discussed, such as an APD. The BLM didn't want us to write directly on the form, but they were acceptable of a condition of approval that was separate on top of the form. So they've never questioned the authority of the state being able to add conditions. However, the only question is not writing directly on the form as was done in the old days. So it just made it a cleaner look.
Was there any discussion about this language change with the BLM for this specific language change? I guess, Mr. Branker, that's supposed to go to you.
Yes, well, as I mentioned, the language that you're deleting in C is not a change, but we did submit this to the BLM, and I think the correspondence we got in return was that they circulated around their folks and didn't have any comments.
So they did indicate to you that they had reviewed it?
Yes, we sent it to them specifically and then followed up later with, hey, haven't heard from you.
What happens, all right, let's say we got purely federal lands. What happens if the BLM approves a form, but then the division denies that approval? What happens?
I can probably answer that the best. So if the BLM approves the form and it does not meet state standards, the OCD may reject that form, but that's not a final action. We may reject it for not meeting certain circumstances to meet that federal application. So, or to meet that application requirement. So the operator then could add additional items to that form and resubmit that form. Sometimes it's the inclusion of a plat that maybe was submitted to the BLM, but not to the OCD. And that goes to point also, pools and things like that aren't regulated by the BLM, they're regulated by the OCD. So there are some applications of an APD that have to be reviewed by the OCD to ensure they're meeting pool rules, those spacing setbacks, those kind of things, because those are regulated exclusively by the OCD. So if the operator fails to, say, submit a C102 with that APD, we may reject that application. The operator then would have to upload that 102 in that package and then resubmit it to the OCD. By rejecting an application, it's not a final rejection that can't be resubmitted. It's saying that the application was submitted was incomplete and needs to be completed and resubmitted.
Is there a mechanism, for example, let's say it's not necessarily a condition, but an outright rejection of the activity by the division that has been approved by the BLM? Is there a mechanism to address that conflict?
Well, I think I stated that previously. If there's going to be a final conflict between the BLM conditions and the OCD conditions, then we would reach out to the BLM and discuss those conflicts and resolve them and get back to the operator. That's a standard process we've done in my career, is if there's a direct conflict, that we work with the BLM to resolve that conflict and then get back with the operator.
Do you know, Mr. Powell, how long that has taken?
Depends on the conflict. It anywhere from a few days to a couple weeks, depending on the level of the conflict. It's not a normal circumstance, so I can't give you a better idea than that. It's more an exception, not the rule, because that's why we require the BLM approval prior to the state approval, is because we try to work within the bounds of the BLM conditions.
But I guess that same process doesn't apply to tribal land.
So historically, the way the tribal lands have been handled is they're reviewed, looked at by the OCD, and then conditions may be placed on there. But if the tribal agencies disagree or have concerns, we then support the tribes in their decisions.
But the tribe is the ultimate decision maker.
Correct.
Okay. And in the federal scenario, is the BLM the ultimate decision maker?
So So with tribes, they're the ultimate decision maker as far as the complete package. With the BLM, we ensure there's not a conflict between the OCD conditions of approval and the federal. So there is a slight difference between the two.
Okay, you said you're sure there's not a conflict. Okay, so if there becomes a conflict and you're working with the BLM, who is the ultimate decision maker if you're at loggerheads?
You know, if there's a loggerhead, we would probably work it out between the legal bureaus, and I don't know where that would go because I haven't experienced that in my career.
Okay. Okay, thank you. That's all the questions I have.
Thank you, Mr. Feldwer. Madam Chair, do you have any questions of the division panel?
If you don't mind, I'd like to go last.
All right, thank
But I
you.
do have questions.
All right, Mr. Bloom, do you have questions of the division panel?
Yes, Madam Hearing Officer, thank you. I do have a couple questions. If Mr. Tremaine, if you could pull up 1915-216, duties and authority of division personnel. I had some questions related to that. You could share your screen.
I am
Yeah.
doing that now. So the proposed rule changes in 1915 to
16.
16. Is that visible, Commissioner Bloom?
That is perfect. Thank you. I appreciate that. And I'll let the panelists here decide who would like to answer, these questions, or you all can determine that. So what we're seeing here is new language that says division personnel may allow minor deviations from approved field operation plans, such as drilling and plugging plans. What do minor deviations entail?
If you'd like, Bill, I can address that. So what minor deviations would entail, and a great example is plugging a well. The operator will submit plugs in a well. There'll be a variety of different plugs, and then they'll go into that well and start working on plugging that well. When they submit their intent, they may not know the entirety of the condition downhole. So as they start going downhole, they may encounter tight spots. They may encounter areas where they can't set a cement retainer, those kind of things. So a deviation may be, an example was in the notice of intent, the operator was going to set a cement retainer at 2,000 feet. Because of something downhole, they may not be able to set it 2,000 feet, but they might be able to set it at 1,980 feet. So they would call in to the division personnel and say, we're requesting to move the plug from 1,980 feet from 2,000 feet to 1,980 feet. And here's some additional cement that we're going to add. So the division of personnel would give verbal approval to do that, or approval to do that. And the reason why that approval is critical to come in this portion of the rule is because there is a rig on site, there's a crew on site, and we don't want to excessively delay those operations.
So currently, does OCD allow minor deviations in or I guess allow minor deviations from approved field operational plans in cases of drilling and plugging?
We do. The difference is just recognizing it under the current structure of the OCD. Historically, it had oil and gas inspectors, deputy oil and gas inspectors, scouts, engineers, geologists. the division duly appoints. For a great example is the geologists that I spoke with earlier. Those used to be stationed in each district office. Now those are stationed under the engineering bureau as part of the permitting section. And they're no longer called division geologists. They're engineering specialists of that group. But it's roughly the same people, same experience that are getting that information and making those calls.
Yeah. Okay. Is someone involved in rulemaking? Sometimes I get concerned about too much wiggle room. What would would you be able to say in what circumstances minor deviations are necessary? Right now, it reads minor deviations from approved field operations plans, such as drilling and plugging plans, but it seems that one could interpret this to read that there are other sorts of plans that could be deviated from in a minor way. Is there a way to precisely define which plans would be allowed to have minor deviations or drop, for example, that the such as from this?
There may be other scenarios where, say, they're doing a well workover and they submitted a condition of approval to do that well workover, and they find different conditions downhole. So it's really any field operations, they could find abnormal events when they go downhole. But I would note, because the way the OCD is structured, the people making those decisions would be the same people that would be approving the original notice of intent. So the review is the same, the expectations are the same, and it's the same people performing those reviews and making sure that they still comply with the other OCD rules, such as isolation of strata, casing requirements, defective casing requirements, those kind of things. So they still, even though they're giving approval for those deviations, now it's codifying that they have to submit those changes on a sundry, but it really is the same person or same type of group that's approving the initial application that would be making these changes.
So this is really just a way to maintain your operational flexibility that you previously had here under 1915-216.
That is correct. And like I said, that whoever's making those changes are still bound by the other OCD rules that regulate those pertinent activities.
Okay.
Mr. Bloom, if I could, Commissioner, if I could jump in, what our initial goal in looking at this section was, when the lawyer and me read it, I went, whoa, that's really broad. And so we started to narrow it down, and then, with Mr. Powell's help, kind of focused in on what are the situations when this is most important. And so that's what we tried to do, to narrow this section down to those specific situations where it's really important to have that kind of flexibility, as opposed to the current language, which says if you want minor deviations from any rule, our field personnel can just give it to you. So we thought, no, let's focus in. So now it's just plans, certain plans that you get deviations from, and plus there's the follow-up, which, as Mr. Powell indicated, is really important. So it isn't just, that's all right, go ahead and do this because it's costing you too much money.
Okay. Yeah, thank you, Mr. Powell, Mr. Brankert. I appreciate that. You've allayed some of my concerns, and I think Mr. Felderwart asked all my questions about your relationship with the BLM and APDs. I was aware of some of that, but didn't know some of the history. That was very helpful. No further questions at this time. Madam Hearing Officer, turn it back to you.
Thank you, Commissioner Bloom. Dr. Ampoma, do you have questions?
Yes, I do have a few questions. And any of the panelists can respond to this. So the first question is, I know the NMOCD has implemented the online submission portal for some time now. So can you comment or can you describe to the commission how effective this online system has been so far?
So I can take that, Bill, if you'd like. It's been extremely effective as far as being able to diversify our reviewers and to be able to track what applications we have. Historically, when we were doing written applications, they were going to a district office. And a great example is the current activity in the state, where the Northwest has very little drilling currently. Where in the Southeast, we have a massive drilling. Historically, the Southeast would get all of those written applications and have to process them without help, essentially. Where the Northwest wouldn't be processing the APDs because there was little activity. Now, with the way that it's online structured, a geologist or environment engineering specialist, as we call them now, in the Northwest is also reviewing and approving APDs for the Southeast. So it's able to allocate our resources more effectively to the areas that need them.
Thank you, very helpful. So how are these applications going to be archived in the online system?
So the OCD, and generally speaking, because I don't know all the IT speak of it, but the OCD has an online portal and it also keeps the online records. So anything that's submitted to the OCD on a sundry is historized in the well files and now in our application submittal portal, where any actions that we take is attached to that well and held indefinitely.
Mr. Powell, when you were explaining the issues with regards to BLM and NMOCD oversight on these applications, you made mention of one instance, especially when there is a pooling application where the federal BLM doesn't deal with that. I want to know, what about if there is a pooling application that involves a tribal land? So how does that, how do you guys deal with that?
So historically, the OCD has set those pooling applications on tribal lands as well, in part of the overall pooling. In consultation with the tribes, if there was ever any disagreement or conflict, then we would go with the tribe's recommendation on approval of those submittals. Because the BLM tribe would have ultimate oversight of those wells on the tribal land.
Okay, very helpful. So you made mention of you don't really know who is the ultimate decision maker when it comes to BLM lands. When there is let's say, if the state and BLM is not able to reach an agreement, do you feel that this issue needs to be dealt with?
Bill, as a lawyer, can probably talk higher than I can, but historically, the OCD has worked really hard to ensure that there's not an ultimate conflict between the two. I think if there was an ultimate conflict and the OCD would be interrupting a federal mandate, the BLM may have an ultimate say for that specific conflict. But maybe Bill has more information on that than I do.
Thank you. As Mr. Powell indicates, we have dealt with these issues innumerable times informally through personal interactions. But that's not to say that, the memorandum of agreement that the MOGA's proposal references would not at some point be a good idea to create a more formal process to deal particularly with conflicts that may need to get elevated. So I think that's something that, the division in our spare time, may try to follow up with.
Okay. So I want to tell you.
I apologize. I was just going to add a little bit to that, Bill. So the memorandum that they speak of, we still have the ability to enter into those cooperative agreements, memorandums, That's also in Rule 2, and we're not changing that portion of the rule. We have the authority to cooperate with other agencies in those types of agreements.
Thank you. So I want to turn your attention to the proposed rule changes in the document. So 19.15.2.17, organizational units. So in that session, you talk about the director may divide the state into districts or other organizational units as appropriate. So I want to know, is it the sole decision of the director to do this, or it has to be based on some consultation?
Commissioner, this would be the director's decision, but obviously, input from not only other OCD personnel, but other people within other stakeholders would influence this decision. I mean, the district boundaries are sort of historic, but at some point they were just arbitrary decisions about which counties fall into which districts. And so we're trying now to come up with more practical solutions about how to allocate these districts in terms of moving resources around. Our districts don't match federal districts, resource areas, et cetera. So, that may be one way of looking at it in the future. But, there may be lots of reasons and other ways of looking at that, but ultimately the decision would be the director's.
Okay, thanks so much. I do not have any further questions.
Madam Chair, can I ask a couple of questions?
Yes, thank you,
Oh, I'm
Commissioner
sorry,
Ampoma.
the hearing officer. My apologies.
That's all right. Mr. Moander.
So, Mr. Brankert, I just want to clarify a few things to make sure I'm understanding the testimony today as well. Is it the intention of OCD under the proposed amendments under 1915-7-9 to violate or ignore federal law concerning federal lands?
No.
Okay. And I realize that seems potentially like a silly question, but I just wanted to clarify that since concurrent jurisdiction has arisen today, to just clarify the division's position vis-a-vis federal law in particular. So thank you for that.
Is that all, Mr. Moander?
Yes, my apologies, Madam Hearing Officer. That's all I had.
Thank you. Madam Chair, do you have questions remaining of the division panel?
I just have a couple questions. In the reorganization that the division has done, have any of the district offices been closed?
No, they have not.
Have any staff been required to move?
No, they have not. But an example of effective use of staff would be southeast part of New Mexico, where it was previously split up into 2 districts, and staff wasn't allowed to cross county lines or district lines because they're really close together. Now that inspection group is 1 team instead of 2 teams, and we effectively send those inspectors where needed, depending on overall availability of inspectors.
Prior to the change in structure, did the division have consistency problems between districts?
Extreme consistency problems, yes.
Has the restructure helped to alleviate those problems?
Yes, it has.
Thank you. I guess probably from Mr. Powell, are you familiar with the quarterly requirements to provide performance measures to the Legislative Finance Committee?
Yes, generally, yes.
Have you been asked in the past to put those responses together for the Legislative Finance Committee on some of the items such as percent of applications to drill that were approved within 10 days?
Yes, I have.
Let's see, for FY21, does it sound appropriate that 87.6% of applications were approved within 10 days? And then our last quarter in FY22, 95.6% were approved within 10 days.
Yes, that sounds appropriate. And I would also note that those were for all APDs, not just state or fee, but also include federal.
So do you think that generally on permits to drill, OCD causes any sort of backlog in timing or process?
No, I don't believe that we cause any backlog in APDs.
Okay, thank you. I'm guessing my question is for Mr. Brankard. It's sort of been asserted, I think, during some of the questions that tribal jurisdictions and federal jurisdictions are comparable. Are there differences between the tribal jurisdictions versus the federal jurisdictions that might be helpful to elicit for the commission in terms of how they function, if they're sovereign nations, things like that, like what the interaction differences would be?
Well, it's just sort of, basic American constitutional law. It's in the Constitution that tribes are separate sovereigns, and they are treated that way. And so therefore their sovereignty is in some ways analogous to a state on their own land. Well, they would never admit that. But the federal system, though, is a system of federalism, which is the states and the federal government sort of share and spread the authority amongst themselves for various things. And there are certain areas where there is exclusive federal jurisdiction. For instance, there is the property clause of the Constitution. And so we as a state don't have a right to veto a federal decision to lease land to somebody. That's their distinction. But when it comes to regulating activities on the land, there's concurrent jurisdiction between the state and federal governments.
Thank you. And so just taking that one step further, there is concurrent jurisdiction between the state and the feds, but there is not concurrent jurisdiction between the state and the tribes, correct?
That's correct. I mean, I think in reality, as Mr. Powell has discussed, we have had a fairly involved process with tribal oil and gas development, which I think is somewhat unique, but it's clear that we don't have the ultimate authority in those situations.
And I think you said this earlier, but did OCD provide consultation with the tribes?
Yes, a copy of the draft rules was sent out to all New Mexico tribes, nations, pueblos.
Did they provide any feedback?
Yes, there was from a few tribes they did, and as I mentioned earlier, they very much wanted to see OCD's role as a repository of information be maintained.
Thank you. Let's see, okay, in 1915, 7, 9, I think it's C1. Yeah, 1915, 7, 9, C1. I just want to make sure I understand this. So it says for subsequent reports of work performed that are first reported to the BLM on a C103 or C105 equivalent, if within 30 days of submittal, the BLM has not approved or processed such submittal, the operator shall within 10 days file the state equivalent form with the division. is that basically, so saying that if the BLM has not approved the form within 30 days, the operator then starting on day 31 has 10 days to submit that form on the state form to the division. So basically they need to submit the state form by the 40th day.
That would be correct.
Okay. Would the division see any concerns with just adding a little bit of clarification in that to say something like following the 30 days, I don't know, shall within 10 days file a state equivalent, just to be a little bit clearer?
I don't see an issue adding clarifying language to that.
Okay, just one more question. So that citation 79C1, and then looking at 19, 15, 7, 16. I want to make sure I'm understanding this right. Are there slightly different, but timelines? Like this seems to say 45 days for a C105, whereas up in C1 above, it might be 40 days, or are these slightly different pieces?
So they're slightly different pieces. They would work consecutively with each other. So the 45 days is they would have to submit their application to the agencies. So on a BLM agency, they would get the 45 days plus then the additional 40 days.
Okay, got it. Just one more question. So back to 79C1. Why is that provision important for the division to have, the requirement to submit on the state form if not approved by BLM within 30 days?
So subsequent reports contain typically critical information to make sure correlative rights and human health in the environment are protected. For example, the C105, that's where we get all of the casing information, completion information, and formation information on the same form. And it's the only place we get formation information from an operator. So having that formation information and then being able to compare it with where they've completed ensures that they completed within zone and that zone is properly isolated, which protects correlative rights and ensures strata isolation, those kind of things. So having a delay in a completion report would be critical for us to make sure that the operator is producing the formations that they should be producing.
Thank you. Sorry, 2 seconds. Does the OCD have primacy for the UIC, which is Underground Injection Control Program, under or from the EPA?
Yes, we have primacy for the UIC events from the EPA for everything but tribal lands.
Does the BLM have that same authority?
Not that I'm aware of, no.
Do you foresee any potential problem? So with some of the proposal by the New Mexico Oil and Gas Association, if there was potentially a well, an injection well that was purely on federal land, you know, do you see any potential conflict with the language proposed by NMOGA that basically says such forms involving exclusively federal lands or minerals are not subject to division review or approval unless it's authorized by some sort of written agreement? Do you think that could be a conflict, particularly for UIC wells that might only be on federal land?
Yes, I believe that would directly conflict.
Because the OCD has primacy for that program and the federal government does not?
That is correct.
So that would inhibit our ability to administer our program potentially?
Yeah, and it would potentially jeopardize that program, ensuring that the regulations we've put in place for the UIC rules to meet that federal mandate would not be enforced.
Okay. I think that's all the questions I have. Thank you, Mr. Rankert and Mr. Powell.
Thank you, Madam Chair. Are there other questions from anyone of the division panel? Please speak up if there are any follow-up questions.
Mr. Orth, may I ask one question about the C-105s under 1915 7.16?
Go ahead, Mr. Feldwart.
Mr. Powell, Ms. Sandoval directed you to that provision. I just want to make sure I understand it, assuming it gets enacted. So if I have operations on federal lands, I'm sorry, if someone has operations on federal lands, when do they file their Form C-105? Is it not 45 days? Did I hear you say it's actually, what, could be 85?
So they would file their C-105 with the regulatory agency, which on federal lands would be BLM first within the 45 days. If
Okay.
BLM doesn't process that within 30 days, then they would have to then file the state equivalent with 10 days after that. So the initial submittal would be 45 days, and then there would be a 30-day period waiting for federal approval, and then a 10-day period to resubmit after that for those two rules to work together.
All right, maybe I'm okay. So do I file within 45 days? Does an operator file the C-105 with the division and the BLM, or with the BLM first?
With the BLM first.
Okay. Okay. And then if you don't receive approval from the division within 30 days of that submission, then you file it with the state.
That is correct. I would note that you could file the 105 earlier than the 45 days under 16, and then the 30 days would start from that point. So say you filed it 10 days after you do your completion.
Yeah.
With the BLM, that 30 days would start at that point. So it's not a cut and dry 45 days plus 30 plus 10. The 30 plus 10 is after submittal to the BLM in that point in time.
Got it. Okay. Thank you very much.
Thank you, Mr. Feldwart. Any other questions of the division panel? Please speak up. No? Well, thank you very much, Mr. Brankard, Mr. Powell, and Mr. Tremaine. We will move then to the Oil and Gas Association, but let me first ask, because we're at a transition point, if there's anyone on the platform who is here to offer oral public comment. If you are on the platform to offer oral public comment and would like to do so at this time, please reach out through chat and I'll accept your comment now. I will also invite public comment after we've heard from the Oil and Gas Association. So this isn't quite the last time, but we'll be wrapping up not too long from now. Anyone at all, just reach out through chat.
I'm not seeing anybody, Ms. Worth.
Okay, thank you very much, Madam Chair. Mr. Felderwart, would you like to offer NMOGA's presentation?
I really have nothing more to offer. I know that there's, when NMOGA initially submitted these proposed changes, I don't know to what extent there was any dialogue as to the reason why they were not accepted. I appreciate the submission by the division's witnesses here today. It's really kind of a legal question. I recognize there's concurrent jurisdiction, but everybody knows there's limitations on that, particularly if you have conflicts between what the BLM is saying must be done on federal lands and what the OCD may be saying is to be done on federal lands. And I think that's where there's a lot of confusion. Perhaps there could be some clarification. It does seem to me that there is some concern when you have the BLM approving an activity on federal lands and the division saying that you cannot, where there's no agreement with the BLM that the division has jurisdiction to, in a sense, veto or nullify approval by the BLM. So that's the concern.
All right, thank you, Mr. Felderwart. Mr. Tremaine, do you have any questions of Mr. Felderwart based on his statement just now?
No, Madam Hearing Examiner.
All right, Madam Chair, do you have any questions of Mr. Felderwart?
Maybe just one. Are you aware of any conflicts in your career that could not have been, that were not resolved between OCD and BLM?
Not that I'm aware of. I know there was a memorandum of understanding for a long time, at least, well, I shouldn't say for a long time, and for part of what you would call my career, that was in place. I think it dealt with a lot of that. And I have been, I think a lot of times this issue comes up with what are we doing with purely federal units? Are we getting division approval for purely federal units, things of that nature? And I think it's been kind of a moving target as to what extent is the division involved in those types of activities. But to answer your question directly, I have not seen a circumstance where it hasn't been resolved so that we didn't have to litigate the issue of can the division come in and regulate an activity on federal lands that is in direct conflict with what the BLM has required.
Thank you. That was my only question.
Thank you. Commissioner Bloom, do you have any questions of Mr. Felderwart?
Madam Hearing Officer, I do not have any questions. Thank you.
Thank you. Commissioner Mpomo.
I do not have any questions. Thank you.
All right. And Mr. Moander, any questions?
No, Madam Hearing Officer, thank you for asking.
All right. Thank you very much, Mr. Felderwart, for your statement. Let me put out a final call for oral public comment. This is your final opportunity to offer that comment. Please reach out through chat if you're on the platform. Okay. Nothing, Madam Chair? Okay. And I believe you confirmed earlier with the commission administrator that no written public comment had been received.
Correct. I believe that they were allowed to be submitted, and correct me if I'm wrong, through noon today.
That's my memory. That's my
Um,
memory.
Ms. Davidson, if you're able to chime in, have you received anything up until now since this morning?
No, I have not.
Thank you.
Welcome.
So, Madam Chair, I believe we've come to the end of the evidentiary hearing on this rulemaking. And you may want to take a brief break before you can deliberate there. But I will turn it over then to you and to Mr. Moander. Thank you all very much.
Thank you. So I think we should probably wait until a little bit after noon to make sure we haven't received any additional written comments. Are there, maybe just a quick question, are there closing statements, or has everything basically been presented at this point?
I can ask. I didn't ask. I see Mr. Felderwert's hand. Mr. Felderwert?
Yeah, I apologize. I was looking through my notes. I may have something that might be of help. I mean, when I'm looking at 1915 7.9, talks about forms required on federal land or minerals, yet there's a provision in there that talks about forms required on what is now Native American nation, tribe, pueblo, or individual allottees. I'm just wondering for those of us dealing with this rule in the future, whether there should be some reference in the title to the fact that this deals with not just federal lands, but perhaps tribal lands or native lands. I don't know what the right term would be, but just a food for thought.
All right. Thank you, Mr. Felderwert. Mr. Tremaine, would you like to address that question?
Sure. To the extent that, I mean, I think it could be appropriate for the title to be amended, reflecting federal lands or minerals or like federal or other interests. I think that would be appropriate. I don't know offhand. I hadn't thought about that question before, so I apologize, but I don't know that is strictly necessary, but Mr. Felderwert does bring up an important point because we are distinguishing between tribal and federal units. So I don't think that the division would oppose any modification to that. And I guess my request would be that we do retain the language that's in the current title and simply add to that to reflect that OCD may act as that repository of forms and information related to other lands besides those federal.
So let me ask a question, Mr. Tremaine. If we were to take a 15-minute break, for example, and you could confer with Mr. Brankard and Mr. Powell, would it be helpful to come back in 15 minutes, offer a brief closing remark, complete with perhaps a suggested change in the title for 1915 7.9? Would that be helpful?
Certainly, I will confer.
All right, Madam Chair, would that be okay if we came back in 15 minutes for that?
Yep, that's fine by me.
All right. Thank you very much. Let's return at noon, please. We'll have brief closing remarks, and then I believe the commission can proceed to deliberations if they choose to do that. Thank you. All right, we are back after a short break. I'll turn to Mr. Tremaine first. Mr. Tremaine, do you have any closing remarks? And in particular, do you have any suggestions around the title of section 1915-7-9?
Certainly, Madam Hearing Examiner. I'll start with 1915-7-9. OCD would propose that that title be changed to read Form Requirements on Federal or Tribal Land or Minerals. And I can distribute that by email or in the chat if that would be helpful for the commissioners. I really have two general comments otherwise. I just want to point out to the commission that as we talked about several times today, OCD's proposed changes serve to update and modernize the rules. These are administrative and procedural changes. They're frankly intended only for that purpose, and they're fairly boring. So these do not reflect any substantive or policy changes on OCD's part. Secondly, I do want to address directly Namoga's proposal, and I'll limit my comments to say that I don't believe that change, proposed change, is supported in the record. I do understand Mr. Felderwert's and Namoga's point, but I think that speaks to an issue of a request for clarity, rather than any specific legal reason why OCD's proposal is inappropriate. The record does not reflect any specific reason to that effect. Rather, that request for additional clarity could be answered and is actually permitted under the rule. MOUs or further detailed agreements between the agencies would be appropriate and permitted as the agencies are available to do so. And those are my only comments. Thank you, Madam Hearing Examiner.
Thank you, Mr. Tremaine. If you would repeat one more time, please, the proposed new title of section 9.
Form requirements on federal or tribal land or minerals.
All right, thank you. Mr. Felderwert, any closing remarks?
No, other than I apologize for not snapping to perhaps that title issue until yesterday. And I totally agree with the change proposed by the division. I think that provides some clarity to anybody looking through the index of the rules.
Thank you for that, Mr. Felderwert. Madam Chair, no one has reached out through the chat or, to my knowledge, in any other format to offer public comment. So I think at this time we'll close the evidentiary record, and I will turn the floor over to you and Mr. Moander. Thank you very much.
Thank you, Ms. Orth. I guess, commissioners, I would propose that we move straight into deliberations. Okay. So I think we should probably take this section by section. Mr. Moander, the procedural question, does it help to do a vote on each section, or like vote by rule, like address each section and then maybe like do an overarching maybe on the rule, each rule?
So you have the option to kind of do this as you like. Unsurprisingly, my neurotic lawyer mind likes the idea of voting on every little change. I also recognize the tedium in doing that. So because this rule is pretty short, at least relatively speaking, and it does fall under its own, it's just one, it's part 2 is all that's being touched on. I do not have an issue with a final vote to accept the changes as will be dealt with in deliberation, but it might be helpful to break it down by subsection. So, we've got 2.7, 2.10, 2.12. I think that might be the best way to make a record, but that's sort of the happy medium between one vote and 1,500 votes.
Okay, that makes sense. All right. Let's start at the beginning, 1915-2.
Madam
the
Chair,
Yep.
customarily, you've had me put the rule up on the screen so we could do real-time changes and you guys, the commission can see what I'm doing. Would you be willing to do that today?
Yeah, that would be a great idea. Let me make you the presenter. And now you should be able to share your screen.
All right. Okay. And I know last time we went through this and the time before that, everyone was getting motion sickness from the changes or moving up and down. So I apologize in advance, but I am at your disposal, Madam Chair.
Make it a little bigger.
Mhm.
Better?
Thank you.
Yes. All right. Start at the very beginning. All right, 1915-2-7, which is the definitions. There were 3 definitions added in A, C, and R. A definition for Act or Oil and Gas Act, which refers back to the statute. A definition of certified mail, which was discussed by, I believe, Mr. Brankard as to why the division is proposing to expand the definition of certified mail outside of just the U.S. Postal Service due to some previous slowdowns and tracking problems. So adding to cover other mail delivery. And then a definition of rules, which basically refers to the rules pursuant to the Oil and Gas Act, 1952 to 1915-39. Are there any edits or changes to this section?
Madam Chair, not on my end, no, thank you.
From my end too, Madam Chair.
Is there a motion to adopt the proposed changes by the division to 1915.2.7?
Madam Chair, I so move.
Madam Chair, I support. I second.
Mr. Molander, would you roll call, please?
Yes, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right, let's move on to 1915.2.10. So this section was renamed. And basically what it does is it tells the division to develop an online mechanism to submit forms and applications. It references the statute that requires fees be paid on those forms and applications. And then it has some language regarding if there's a technical failure of the system. I think this was discussed by both Mr. Brankard and Mr. Powell as to why the division is moving to an online system. You know, what that does for modernizing the division and streamlining processes. And so they provided testimony on that. Are there any proposed edits or changes to this section?
No, Madam Chair.
No, Madam Chair.
Mr. Molander, another roll call, please.
Yes, Madam Chair. Dr. Mpoma.
Oh, I'm sorry, do we need a motion?
Actually, you do. That's a good point.
I do need a motion. All right, is there a motion to approve 1915-210 changes as proposed by the division?
Madam Chair, I so move.
I second.
Now would you do a roll call vote?
Happily, Madam Chair. Dr. Mpoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair,
Approved.
motion carries.
Thank you. All right, the next section, let's see, is 1915 2.12, which is being repealed and replaced with a new section and proposed language. The previous section was titled the numbering of division orders. It is now going to be titled filing and notification. And the previous language was struck. So this section, basically what it does, it tells you how to file, and I think Mr. Brankard described throughout the OCD rules, it refers to how you can file with the division and in the appropriate district offices, and in lieu of changing every single rule that OCD has on the books, this section was meant to sort of be an overarching instruction section and accomplish that. And testimony was provided, I think, by both Mr. Brankard and Mr. Powell as to, again, why this makes the most sense and how it modernizes the division and tracking and processes. Are there any comments or edits to this section?
No, Madam Chair.
No, Madam Chair.
Okay, is there a motion to adopt the new language in 1915 2.12, repealing the previous language as proposed by the division?
Madam Chair, I so move and would also move to approve the new language as well.
Madam Chair, I do second.
Mr. Moander, roll call, please.
Yes, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right. Moving now to section 19.15.2.13, computation of time. I believe Mr. Brankard spoke about this in his testimony. You know, I described the edits and changes to comply with the Uniform Statute and Rule Construction Act, which is NMSA 1978, section 12. -2-7 and detailed as to how that would work and why the change was being made.
Madam Chair, I believe it's section 12-2A-7, just to clarify.
Oh, I'm sorry. Rolling too quickly. Yes, thank you. Are there any edits or concerns regarding this section?
No, Madam Chair.
No, Madam Chair.
Is there a motion to adopt the changes to 19.15.2.13 as proposed by the division?
Madam Chair, I so move.
Madam Chair, I second.
Mr. Moander, would you do a roll call, please?
Yes, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right, next section is 19.15.2.16. There are proposed changes to both the title as well as the content of this section. I believe both Mr. Brankard and Mr. Powell discussed this section and that the modifications were made to both sort of narrow the previous language and also make it align with how the division currently functions, in that they are division personnel as opposed to field personnel. Yeah, are there any edits or questions on this section?
Madam Chair, I raised a question about the such as being potentially not necessarily broad. So I thought I'd flag that again in case either of you share any of those concerns. But I think overall my concerns were allayed by the further testimony of Mr. Powell and Mr. Brankard under cross-examination.
I do not have any questions on this.
I think any questions I had were answered by Mr. Powell following what you brought up, Commissioner Bloom. So I am good with the language as is currently proposed.
Very good, Madam Chair. Then I would move to approve the changes to 1915 to 16.
Madam Chair, I do second.
All right, Mr. Moander, would you please do a roll call vote?
Yes, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries. Madam Chair, just a brief Scrivener error I see before you proceed to the next section. And if I'm wrong, hopefully Mr. Tremaine will correct me, but I believe that should read in italics just above the excised version of 1915-217. That should likewise read the italics 1915-217. Is that right, Mr. Tremaine?
I believe that is correct.
Because it looks like the right below the excise language is the new 1915-217.
No, I think that's correct. I think it was overlooked simply because there was also the repeal of 1915-212.
Which is
so
not, I'm not blaming anybody here, just so we're clear. But just to clarify what's happening here.
absolutely, yes, that should refer to 217 as both 212 and 217 current versions are repealed by the proposed amendments.
Thank you, Mr. Tremaine.
Thank you for catching that, Mr. Moander. So this section, with the modification that we'll need to ensure that modification, I think, gets made, because the proposal was to repeal the current 1915.2.17 district offices section and replace it with a new 1915.2.17 section titled organizational units. I believe, again, Mr. Brankard and Mr. Powell both spoke about this section and sort of described the history of the division and why it was set up previously, how it was, and how that no longer reflects how the division operates, and also, allows the division more flexibility to set up its own organizational units as makes sense for modern time and functionality. Is there are there any edits or comments in this section?
No, Madam Chair.
Okay.
No, Madam Chair.
Is there a motion to approve these changes with the modification that the text should read repeal current 19.15.2.17 and replace with new section as opposed to 19.15.2.12?
Madam Chair, I so move.
Madam Chair, I second.
Mr. Moander, would you do a roll call, please?
Yes, Madam Chair, just a point of order. That motion all included the full replacing language because I wasn't sure I caught that correctly. So it covers all the changes that are proposed for 1915-217.
Correct. Both
Okay.
the repealing of the current language and the replacement with the new language.
Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
The motion carries.
All right, that takes us through the changes as proposed by the division of 19.15.2 in MAC. We can move down into 19.15.7 in MAC, which is titled Forms and Reports. All right, the first section here in 19.15.7.8, again, this, I think Mr. Brankard and Mr. Powell spoke about this. This helps to modernize the division and aligns things with an online reporting mechanism so that all of the submittals go onto that online portal as opposed to being turned in person. Are there any questions or edits for A?
No, Madam Chair.
Okay.
No, Madam Chair.
All right, let's now look at 19.15.7.8B. There is a minor change to the end of this section. I think just sort of aligning with the Oil and Gas Act and the language in there in that section. Any edits or questions on that?
No, Madam Chair.
No, Madam Chair.
Okay, C, same thing here, just sort of streamlining the language instead of listing all of the potential types and potentially missing something. The language reads, a person subject to the Oil and Gas Act. Are there any edits or questions, comments on that?
No, Madam Chair.
No, Madam Chair.
Okay. Let's look at D. So under the written notices, request permits and reports, this again once again aligns with the division's intent to use an online platform to collect forms and turn those forms in, as well as states explicitly that this list is not intended to be comprehensive necessarily, and it does not limit the division's authority to develop any new forms as are necessary. Are there any questions or edits to that section?
Madam Chair, if I look at this correctly, I think it's on D10. It looks like there's also the word produced was added for the form C108.
Oh, thank you.
Let me just check, make sure there's nothing else. Okay, I think that's it.
I think so. The division has a whole lot of forms.
Madam Chair, you, on this, on D, we have the following list of forms is intended for informational purposes. Is not intended to limit the division's authority. I don't know if we would just want to say and does not limit the division's authority, or it might make no difference. I'd flagged that. I probably should have raised it in our questioning, but I think it's fine. I guess it's fine either way. So,
Commissioner Bloom, so your language would be, I would describe your language as stronger, much, I want to say clearer, but it takes a stronger position on the fact that the list would not limit the division's authority. So just from a statutory or regulatory construction perspective.
I'm fine with making that change. I think that's what the language was, to use that language, intended to do. But I agree that your language, Commissioner Bloom, is a little bit stronger and would be appropriate.
Okay, thank you.
Commissioner Impoma?
Yeah, I'm okay with the change.
All right. And then, let's see, Mr. Moander pointed out that in 1915.7.8 D10, there was also the addition of the word produced. I think that addition just makes things a little bit clearer. Generally, it's referred to as produced water, not salt water. And so I think that just provides clarity in the rule. All right, I think that, oh shoot. I think that is all for the changes in 19.15.7.8. Just opening it back up, are there any questions or edits on anything in 19.15.7.8 as proposed by the division?
No, Madam Chair.
No, Madam Chair.
Okay. Is there a motion to approve 19.15.7.8 with the changes to 19.15.7.8D that were proposed?
Madam Chair, I so move.
Madam Chair, I second.
Mr. Moander, would you do a roll call vote, please?
Yes, Madam Chair. Dr. Impoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
Madam Chair, when you mentioned that when we initiated that motion there, we certainly noted the changes to D, but did we, with that motion, adopt all the changes to the entirety?
Could we have the court reporter read the motion back for us just to check? If she's available.
I'm available. Give me just a second.
He's looking.
Thank you.
Is there a motion to approve 19.15.7.8 with the changes to 19.15.7.8D that were proposed?
I think that motion works.
Yeah, okay.
Okay, you were able to hear that?
Yes.
We were.
Okay, great. Thank you.
Thank you for reading it back.
No problem.
All right. So the next section, I think let's take these and do the repeals first and then go into the replacement pieces. First off, there are proposals to repeal 19.15.7.9 and 19.15.7.10 as they currently read in the rule. Again, this was, it aligns with the modernization effort and to start to work online as opposed to filing things in person on paper. Are there any questions or edits to the repeal portions of 19.15.7.9 and 7.10?
No, Madam Chair.
No, Madam Chair.
All right, Mr. Moander, would you do a roll call?
I think we need a motion first.
Yeah, I keep getting just too excited. Is there a motion to repeal 19.15.7.9 and 7.10 as are currently written.
Madam Chair, I so move.
Madam Chair, I second.
Would you do a roll
I
call,
will,
please?
Madam. I will, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right. Let's now move into the replacement for 19.15.7.9. And then we can move into, I think, the repeal of 11 and 37.
Madam Chair, this is Felicia. May I make an observation here, please?
Please.
When I invited Mr. Tremaine to name the, provide a new name for this section, he actually used the words "or minerals." So it'd be form requirements for federal or tribal lands or minerals.
Thank you, Ms. Ord. I knew I missed something on that. I appreciate it.
Is it for, or is it supposed to be on requirements? I thought he said on. Does it matter?
So I believe Mr. Tremaine can clarify now.
Yes, we should ask Mr. Tremaine.
I did say on. I don't know that it actually makes a difference, but the proposal was form requirements on federal or tribal land or minerals.
On would align with how the language is currently on there, which is forms required on federal lands or minerals. So
It matches subsection A for wells on federal lands.
yeah.
Yeah, it uses, yeah.
Okay. Let's take 19.15.7.9 and the new language, and then we can jump back up for the repeal of 11 and 37. Okay, so I think that captures what the changes were for the title. Let's start with A. So a lot of this language is, you know, I think, and Mr. Brankard and Mr. Powell discussed this during their testimony. Part of what was intended to do was get rid of the hard references to the BLM form numbers. So in case they change their rules, you know, our rule is not immediately outdated. So more generalized references in A. Any questions or edits, comments on 9A?
No, Madam Chair.
No, Madam Chair.
Okay, let's move to B. All right, this section. Again, this just helps to modernize things, geophysical logs, electronic logs, other testing results, you know, they shall be submitted on an electronic copy using that online process, you know, for federal lands or minerals. Again, this just helps to modernize things. Logs can, when submitted on paper, can actually be you know, maybe challenging to scan. And Mr. Powell, I believe, discussed this section. Any proposed edits, or comments on this section?
No, Madam Chair.
No, Madam Chair.
Okay, C, I believe that C is where Namoga made their proposed edits. And Namoga proposed to strike first sentence and then get rid of for approval within C. So for approval was on line 1, 2, 3, 4. Generally, I don't think that I heard testimony from Namoga that really backed up as to why this change should be made. I think the division provided extensive testimony on how the process has worked in the past. I believe upon question, there have been no such issues of conflicts and issues. And Mr. Brancard discussed concurrent jurisdiction and generally how that works. My proposal would be to keep the language as is by the division and not adopt the changes as were proposed by Namoga.
Madam Chair, I agree. I also had some questions coming into this about the historical relationship between OCD and BLM and how APD approvals and other sorts of approvals were handled and what the nature of these overlapping jurisdictions is. But having heard Mr. Brancard and Mr. Powell's answers to Mr. Felderwert's questions, I felt that these changes, I shouldn't say changes, I guess because some of this language was actually previously in the rule, that this language that we're seeing before us is correct and warranted. So I have no further concerns or questions about the proposals at this time. Thanks.
Yeah, Madam Chair, I do support the argument made by yourself and Commissioner Bloom. So thank you.
Okay. On C, so it would be 9C1. My only thought here would be, I mean, when I first read it, I just had a little bit of a hesitation if the 10 days backed up off of the 30. I'm wondering if there's just a simple way to clarify it. The BLM has not approved or processed such submittal. The operator shall within 10 days following the initial 30 days or following the 30 days, something like that.
So, Madam Chair, I've read this several times. I understand where the argument comes from about trying to simplify this, but this reads like a fairly typical regulation. And the way it's structured is you submit to BLM, and within 30 days, if you've not gotten an approval or it's the other, well, stepping back, the other thing is approval or processed. So approved is different than processed. Processed strikes me as the application is now under consideration. That's fundamentally distinct from a not approved or approved, whatever the case is. But the other thing is, I think the way that you take that out for a second, take that clause out, and I do recommend adding a comma behind submittal to just clarify that that's an independent clause. Within 30 days of submittal, the operator shall within 10 days file. I do think that's pretty legible from a legal perspective. I don't know that trying to simplify it may actually make it more complicated. And I've seen that happen, which will have the opposite of the intended effect here.
Okay, if I'm the only one who struggled reading that, then I'm fine leaving it as is. Commissioners, were you clear when you read that?
Yeah, I'm okay with it. Yeah, it seems clear to me.
Been hanging out with lawyers quite a bit there, Doctor. That's starting to read things the way we do.
And yes, Madam Chair, I'm okay with this.
Okay.
And again, to point out, I'm recommending that comma behind submittal to separate the clause. That's just me. I don't expect to get my neuroses.
Okay. Do we need to talk about, since you brought up the BLM has not approved or processed?
Yeah, I just caught that because that's something that when I look at it, I'm like, well, there's a distinction from, and I'll just shorthand it, a rejection rather than not approved, or whether something's in process. I mean, those are two different functions. Because what I see is knowing how the federal system works, something being in process, and I will say I'm not knowledgeable, at least not thoroughly, on BLM regulations vis-a-vis this regulation, but that could be, when I read that, I read open-ended is what I read. It's in process. So I think you guys are well within your rights to examine that.
Madam Chair, let me ask, I guess it's my understanding that an operator can see if their C-103 or C-105 is being processed. But I'm also wondering here if it's not more clear, and perhaps it gets to where OCD needs to be, if we were to strike or processed, so that it would read, if within 30 days of submittal the BLM is not approved such submittal, the operator shall within 10 days file the state equivalent form.
Yeah, I'm trying to rack my brain. I don't know if all forms are quote approved. I think some of them are filed and they're processed, like it's been received, it's complete. But you don't get like a year approved. I mean, it's like a sundry, right? So I think approval could probably still work in those situations. It's like somebody, I think that's where it's trying to get, is somebody has, like, it's a sundry, right? And somebody's received it, it's complete, it's verified for completeness, and it's good to go, as opposed to they reviewed it and it's missing 3 pieces of information, so it's rejected. But processed isn't always the same as approved. But I'm wondering if there's another word we could use, or if approved would still probably cover those situations. Like, it was received, it's complete, it's approved.
And Madam Chair, that's a good point, because I think if it's not rejected, then what is it? I mean, one could presume it's approved. Like, there's no objection to it.
Yeah,
Chris,
when I was reading this, I was thinking about APDs where we can see that they're being processed, and then later on we know that they're approved. But Roy, I hadn't thought, Madam Chair, about what you just mentioned, where there are some forms, C-103, C-105, that could just be submitted to BLM and they process them without an approval. So In that case, this language may very well stand unless we can think of another better way to clarify.
Dr. Mpoma, it sounds like you had a thought.
Yeah, so what I was thinking is normally when you submit the application, it needs to be processed for completeness. So sometimes you will see that once you submit it to be submitted, but once it has gone through the initial review, then you see it will change to under review. Right. So I don't know if that distinguished that.
It's sounding like process.
What if we said process to completion?
Let me see.
Approved or processed to completion?
It's not, has not processed to completion or approved.
Oh.
Has not approved or processed to completion such
Completion. Yeah, that works.
We could always put that draft language in there and then come back to this at the very end if we want to let it sit for a minute. Okay.
1 second. Okay. So I think we're now on C sub 2.
C sub 2, NMOGA also had proposed changes to this part. This is where they proposed to add the language, such forms involving exclusively federal lands or minerals are not subject to division review or approval unless such review is unless such review or approval is authorized by a written agreement between the BLM and the division. So I think there was pretty extensive discussion on this. And it also tracks similarly to the discussion we had on C above. One, I think Mr. Powell discussed how the OCD system tracks things, and that if there are any federal minerals, it is, even if it's 1%, it's termed federal land. So one, it would be challenging to track. And also just historically how the OCD and the BLM have worked through things and have not had any problems, nor has the OCD been really a holdup on the processing side. Additionally, I think there were concerns raised about the OCD having primacy to the UIC program, exclusive primacy, even on wells exclusively on federal land, and that language could create some potential problems being able to administer that program. I think, again, sort of tracking what we said above in C, I think there was not enough testimony in my mind on behalf of NMOGA as to the jurisdictional pieces and why that language should be added or the problems that it is solving. And it would be a pretty extensive policy change on the OCD side. And again, Mr. Brankard, I think, described the concurrent jurisdictional pieces well and distinguished how concurrent jurisdiction on federal land is very different from dealing with a tribal government who that's a different situation than dealing with the federal lands. So I would propose to not adopt the changes that NMOGA proposed in 2 and adopt the changes that were proposed by the division for C2.
Madam Chair, I concur.
One quick.
Madam Chair, I do support.
On C2, for the sake of consistency, and I'll scroll up, in C1, the commission's considering the phrase process to completion. I'm going to recommend that that same language be used, although slightly modified in sub 2 as well.
Agree. I think whatever we end up ultimately deciding on for 1 makes sense to add to 2.
Also,
Madam Chair,
sorry, go ahead, Dr. Ampoma.
yeah, so a quick question is, can we ask NMOCD to clarify, or the lawyer to clarify, why they are using the processes or approves, if there is any understanding behind that?
No, at this point, we have closed the record and we
Okay,
cannot
okay.
ask the parties for any additional information or testimony.
Thank you.
And Madam Chair, on to, I'm wondering just to kind of keep the language parallel. In the last half of the sentence, we said the operator shall file within 10 business days the submittal process to completion or approved by the BLM.
Yeah, I think we have to add it twice in that section, Mr. Moander.
I knew I saw another.
Maybe
And we
we
may
could
want
do
to
a
put,
word search.
and we may want to put approved after that, just so that it follows it's parallel to the beginning of the sentence.
It's identical structure. I like it.
Yeah.
Oh, well, let me read this again. Something is wrong here. Oh, okay. That's just in my head. There's just sometimes certain phrasing will drive me nuts, not because it's wrong, it's just personal taste. But okay, I think that's looks correct.
Okay. All right. Let's look at D. We can circle back to 1 and 2 of C, maybe at the end, but let's look at D. So D basically just says that all forms for basically lands that filed exclusively for lands or minerals owned by Native American nation, tribe, pueblo, or individual latis should still be filed with the division, but the approval portion of that has been removed. Mr. Brankard discussed that at the beginning as to, historically that had been there, but, for some time, the division has not functioned in that manner. But when outreach and tribal consultation was done with the tribes, they did still request that OCD continue to be a repository of information and collect the information online. And so the language to continue to submit them to the OCD was retained and is reflected in D, but the approval pieces have been removed. Are there any questions or concerns with D?
No, Madam Chair.
No, Madam Chair.
Right. Let's look at E. This one is just for other reports. The operator shall file the applicable state forms with the division. Again, just continuing to align the remainder of the rule. Any questions or edits to E?
No, Madam Chair.
No, Madam Chair.
Okay. Okay, so let's address a chunk of this. Is there a motion to adopt as written by the division 19.15.7.9A and B, D, and E?
Madam Chair, I so move.
Madam Chair, I second.
Would you do a roll call vote, please, Mr. Melander?
Of course, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
motion carries.
Okay, why don't we come back to C at the end? All right, let's see. The next piece of this was proposal to repeal 19.15.7.11.
Madam
And
Chair, can I have just a second to put some notes in? Thank you.
Yeah.
Okay. I think I'm where we need to be.
All right, the next proposal was repeal 19.15.7.11 and 19.15.7.37. Basically, the new language in 19.15.7.9 covers what these sections were intended to previously cover, and has been restructured as was discussed above as to why, just to continue to modernize the rules and streamline them and provide clarity. Are there any questions or edits to the repeal of 19.15.7.11 and 737 being replaced with the new section 9?
No, Madam Chair, no questions or concerns.
No, Madam Chair.
Okay. Is there a motion to repeal 19.15.7.11 and 19.15.7.37?
Madam Chair, I so move.
I second, Madam Chair.
Would you do a roll call vote, please, Mr. Melander?
Absolutely, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right, last section where there were changes is in 19.15.7.16A. So the first set of changes were to remove the verb or the words district office and appropriate, again, to align with the structural changes that were described by Mr. Powell and Mr. Brankert, as well as the edits in 19.15.2 that were just made, as well as to add the language or suspend injunction authority as appropriate. I believe it was Mr. Powell who described that there was currently a gap here because the language right now says the division shall withhold the allowable for the well, which only applies to production wells. So there needed to be the same type of action for injection wells, which would be suspension of injection authority. So it basically closes a gap or a loophole that was previously in that section. Are there any edits or questions on the changes to 16A?
No, Madam Chair.
No, Madam Chair.
All right. Is there a motion to adopt the changes as proposed by the division to 19.15.7.16A?
Madam Chair, I so move.
Madam Chair, I second.
Would you do a roll call vote, please, Mr. Moander?
Absolutely, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair.
Approve.
The motion carries.
Thank you. All right, so let's jump back up. Mr. Moander, I also see in section C, third line. Yeah.
And one of the things,
And the last line in C.
let me take one quick look here.
Just did a word search and I think that's it.
It looks like it. Looks like, ooh, we might have to revisit D.
Yeah, right there.
Okay.
At the end of the first sentence.
Okay.
Do we want to, Madam Chair, potentially vote, motion and vote on these previous fixes and then go down to D?
Yeah, we can do that. I mean, let's just circle back. Are we good with that language? Process to completion. I can't think of a better way to say it.
That works for me, Madam Chair.
And Madam Chair, would you want us to bring the process to completion first before the approval to be consistent with that?
I guess we have it both ways. We have process to completion first,
Tell you
and
what,
we have it second.
if the commission would like me to do it, I could go back upon doing these edits. And if you grant me authority to unify and standardize the sequence of these two terms. So you can vote on that here in a minute if you want me to just take that and get that done.
Okay.
And Madam Chair, Ms. Moander, one thing that, and another thing along those lines, perhaps, and Madam Chair, Dr. Mpoma, this might be questions to you as well. I know sometimes when rules are submitted or language is submitted to the state that there's common capitalization. I don't love it. For example, when a division's name is titles all spelled out in lowercase, so you have like OCD, and it's all in lowercase. But here throughout this document, we have Native American with the native with a small n, and just did a Google search, and there's some consensus out there that a small n Native American is somebody that was born in the U.S. and a Native American, the capital N, is refers to a member of a tribe in the U.S. But I don't know if this, if we'd want to update that, or if it'll just all get reduced to lowercase, like we see when things go off for publication.
I think we
Go ahead, Madam
could
Chair.
try to capitalize it, and then if the record center changes it, then they have to change it, but at least we would have tried to correct it. Mr. Moander, do you have a better idea?
This is not something that I put a lot of thought into. I don't have a problem. I mean, here, if there's an issue when we submit it, I will know about it in advance. And I mean, that change will just have to be made as a scrivener's change because it has no impact on substance. So I kind of leave it to you guys. I don't actually know the answer to that question. But we will be told if it's a problem, and it would be changed.
Okay, so if can we make a motion to give you the authority to capitalize native?
Sure.
Okay.
And
Is
you could
there a
probably put in
motion?
that. Why don't you put in the same motion giving me authority to make consistent the phrase process to completion or approve? I will just go through and make sure that's consistent through the document.
Okay.
And Madam Chair, if I might, this is Felicia.
Mhm.
Typically, as the boards or commissions are wrapping up their deliberations, they authorize staff to make whatever non-substantive edits are necessary to be accepted by the State Rules Center or the State Records Center. So I guess I would just ask whatever authority you're giving to Mr. Moander also be extended to whatever staff are actually putting the rule into its final format for acceptance.
And I agree with the hearing officer's commentary, Madam Chair.
Okay, so let's take this back in pieces. So going back to 19.15.79C, is there a motion to adopt the language as proposed by the division, with the exception of adding to completion after the word processed in every instance in C and C1 and C2?
Madam Chair, I so move.
Madam Chair, I second.
Would you do a roll call vote, please, Mr. Moander?
Happily, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair.
Approved. Okay, we had previously approved section D under 19.15.7.9, but since then have found that we need to make a small change to ensure consistency with the remainder of the changes in the rule. And so we should, where again it says processed, add the words to completion following that language. So is there a motion to readopt 19.15.7.9D with the additional language to make it consistent with 19.15.7.9C?
Madam Chair, I so move.
Madam Chair, I second.
Would you do a roll call vote, please?
Yes, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair.
Approved.
The motion carries.
Okay, now is there a motion to give Mr. Moander the authority?
Madam Chair, why don't we follow the hearing officer's recommendation? Oh, wait, I guess I interrupted you. So we want to make sure we include the support staff too, just so we got that motion thoroughly done.
Okay. So is there a motion to give Mr. Moander and any associated division or MNERD staff to make consistent the language approved or processed to completion in the document to ensure that the structure of that is similar throughout the document, as well as change the capitalization throughout the document of native Native American, capitalizing Native throughout the document, as well as make any edits that are necessary to be accepted by the Record Center.
Madam Chair, I so move.
Madam Chair, I do second.
Would you do a roll call vote, please, Mr. Molander?
Yes, Madam Chair. Dr. Mpoma.
Approved.
Oh, so Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries. Madam Chair, could I just have a minute to make sure, I'm going to go through and ensure I've got a vote for everything we needed done.
Yep.
All right, Madam Chair, I'm satisfied that we got everything covered that needed to be covered.
All right, great. With that, I guess, Mr. Molander, would you put together an order for the commission to vote on at the July 14th?
Yes, Madam Chair, I'm happy to do that, and thank you for accommodating both myself and the court reporter on getting this done. I don't think between the two, she and I, we were going to make this happen by next Thursday.
Yeah, the July 14th date seems most appropriate. All right. Well, with that, Mr. Molander, do you have any update on pending litigation for the commission?
It's the same case we've been talking about for 6 months. Nothing, I've been notified of nothing, nothing's changed. So we're still waiting on the Court of Appeals to give us a final ruling.
Okay. Is there any other business before the commission? With that, our next regularly scheduled meeting is on June 9th, which is next Thursday. And we will adjourn for the day. It is 1:13 on June 3rd, 2022. Thank you, everybody, and have a great afternoon and weekend.
Thank you all.
Bye.
Appreciate it. Bye.